Good morning.
Now try again, Barbara.
Uh-oh.
That's not good.
Good morning.
Good morning.
You're the only one there, Julie?
Excuse me? They all
Are
left.
you the only one there?
They all
All
left.
left.
They're here.
I think I can get the podium, I think I can be better. But Jean.
Actually, I do.
I can move it forward a little bit because it is now.
There we go.
This makes Joe.
That's fine.
Now,
Yes. You start with something.
never got that. Never got it. Sorry.
Gonna mute everything for a second, Ed. I wanna test, I'm gonna mute you. I'm gonna test the volume on the YouTube.
Sure. Whatever you want to do. Yep.
Whatever. Everything.
So we're not expecting Mark. Is that correct? Is he out?
That's correct.
Okay. So we have the four of us. That's Megan.
Yeah.
Actually, also just. Okay, I can. That's like all of this. It is not worth something to touch if it's.
Michael?
Yeah.
Thinking about why this query isn't working.
I do not. I do not.
Where was
The
it?
power's on that it's plugged with.
Gonna see how many JDs are required.
There you go.
I think clearly offering.
I do that with mine now frequently. Sweetie, is it plugged in?
Is it on or off?
We were both on the, like, check it.
When you guys get a chance, pick something to want your pizza and I'll order around 11:30. Does that sound good?
Yeah, that's.
And they're really good.
I've heard-
And I'm a food snob because I.
Yeah, no, I've-
This year,
yeah,
I'm glad you.
They actually,
These guys are so good.
oh, same thing, my daughter said, oh, good. Oh, yeah.
So.
Well, my opinion, the first one. Wondering, really?
Jolie, was that working for you now?
But I'm not a sandwich girl, so what?
Megan.
Amy.
What's that?
It's working now?
Check it. Check it out.
Maybe to put it, is it blue? Maybe they need coffee top. I think Whipper is why I live right basically next to it. Yeah, I'm not saying. No, I know, and I think it's because as a little kid, Yeah. We still go to river, so it's one of those. Yeah.
So we ready to go, folks?
So let's do it.
Okay. Good morning. My name's Ed David. On behalf of my fellow commissioners, I welcome you to this meeting of the Maine Human Rights Commission. Before we proceed with the business of today, I'm asking each of you who may have an electronic device, cell phone, pager, etc., to ensure that they are silenced now. We have additional agendas, including the consent agenda available in the back of the room. The consent agenda is a listing of cases in which no written arguments were made to the commission in the allotted time, and the commissioners will vote on those cases, and they will not be considered further today. The remaining cases on the agenda today are coming before the commission to determine if reasonable grounds exist to believe that unlawful discrimination has occurred. The commissioners have received and reviewed investigators' reports and any written submissions submitted within the allotted time. No new information or any written materials will be accepted today. Cases will be called in order on the accepted agenda. As I call each case, the party who has submitted a written argument will be called to the podium to provide the most relevant arguments to the case. The time is limited to 10 minutes. Time may be reserved to rebut opposing arguments, but the time limit of 10 minutes may not be exceeded. Procedural rules of the commission specify that your arguments may address only one relevant factual errors, relevant omissions from the report of facts submitted during the investigation, relevant issues and questions concerning interpretation of the law. The commission allows parties who do not agree with the investigator's report to rebut comments made by the opposing party. Please be advised that the commissioners may ask questions. I'll ask you to please introduce yourself as you come to the podium or appear online. First order of business is we have a quorum. Commissioner Walker is absent this morning, but there's 4 of us in attendance. The first item is the adoption of the amended agenda. I think that the amendment only deleted the one case. Am I correct on that?
Correct. One of the case that was supposed to be heard second has been tabled, and that is the only
Right.
change to the agenda.
Okay, so what's before us is adoption of the agenda and consent agenda. I would hear a motion.
Okay. Great. Have a motion and a second. Pursuant to our remote participation policy, the commissioners must indicate their vote both visually and audibly. Commissioner David,
Yes.
Commissioner O'Brien.
Yes.
Commissioner Douglas.
Yes.
And Commissioner Sanders.
Yes.
Great. Next up, we've got approval of the minutes for the July meeting. Do we have a motion?
So moved, second.
Okay, great.
Yeah.
Commissioner David,
Yes.
Commissioner O'Brien.
Yes.
Commissioner Douglas.
Yes.
Commissioner Sanders.
Yes.
Great. Director's report.
And directors, yes.
As you'll notice, there is no director. So buckle in, folks. Let's see. For personnel, we have to inform you that one investigator has left the commission. For compliance, we've got a memo from Jane indicating that we've got 2 cases in active conciliation, 2 that were unsuccessful, and 1 case that was successful. So with regard to the successful conciliation, I need a motion to approve that agreement in the case PA 23-0152 Hall versus Hometown Health.
So moved.
So moved.
Beach.
Great. Commissioner David is frozen.
I'm sorry, did you call for the vote?
I did.
Yes. Yes.
Yes.
Commissioner O'Brien.
Yes.
Commissioner Douglas. Commissioner Sanders.
Yes.
All right.
Let's go.
Just hold on something. You also have a number of memos from Jane. 3 recommending dismissal of conciliations where the parties have fulfilled all the terms. The other one we just voted on. So the three that we are looking to dismiss are H 21-0127, which is Malcolm versus Apartments at Brunswick Landing. E 22-0125, Ham versus Pratt and Whitney, and PA 22-0308, Stone versus Broadwater. I think we could take them all together and just move to dismiss. If you have questions, please direct them in Jane's. We have a motion. Do we have a second?
Second.
I've lost my checklist. Hang on. Excellent. It's been moved and seconded to dismiss those three cases. Ready for the vote. Commissioner David.
Yes.
Commissioner O'Brien.
Yes.
Commissioner Douglas.
Yes.
Commissioner Sanders.
Yes.
Excellent.
And Barbara, you need somebody to sign, the conciliation agreement. I would ask Commissioner O'Brien to do that since I'm not there.
I forgot to print it, but that would be excellent. We'll make sure you get that, and if not, I can sign.
Oh, okay.
Auto pen.
No,
Don't go there.
We'll take litigation after executive session. And as far as new business, the only thing I have is the new schedule for 2026. This says 2025, but it's 2026 meeting schedule. So that was there for you all to review, and I am looking for a motion to adopt.
So moved.
Second.
Okay, Commissioner David,
Yes.
Commissioner O'Brien.
Yes.
Commissioner Douglas.
Yes.
Commissioner Sanders.
Yes.
Oh my God, we made it through it and we have time to spare. Shall we be in recess?
We'll be in
Yes.
recess until 8:45.
Thank you.
Okay, we ready to go, Barb?
We're ready.
Okay, let's take the first case on the adopted agenda, and that's Dr. Pianka versus Central Maine Pediatrics and Central Maine Healthcare System. There are 4 recommended findings, 2 for reasonable grounds and 2 for known reasonable grounds. We'll take the reasonable grounds first, being the more critical, and therefore we will hear from respondent.
Hi, good morning. Harper Weisberg with the law firm Preddy Flaherty, appearing on behalf of Central Maine Healthcare and also Central Maine.
Just a minute, one moment, attorney. This is Megan Sanders. I'm recusing myself from this matter and leave it to the permanent commissioners.
I would also like to ask if you would like to reserve some of your time.
Yes, I'd like to reserve 2 minutes, and thank you, Commissioner Sanders. I also didn't want to forget to mention I'm also joined today by my colleague, attorney Peter Callahan, who's also on Zoom with us this morning.
Great, and just a reminder, if you could please, and this goes for everybody, not use third-party names when you're making a presentation. We gave folks pseudonyms or titles, and if you could use those because third-party names are confidential, that would be great. You can go ahead anytime.
Absolutely. Good morning. As stated in respondent's submission, the commission should find that there are no reasonable grounds to believe complainant's termination was discriminatory based on sex or in retaliation for reporting discrimination. The investigator's report already contains all the relevant ingredients required for the commission to issue a finding of no reasonable grounds on these claims. The reasons are twofold and they're straightforward. For the patient safety retaliatory claim, the investigator appropriately credited respondent's legitimate, non-discriminatory reason for the termination, which was complainant's attitude towards supervisors had soured to a point beyond repair, and that this had negatively affected the work environment. However, for the 2 discharge claims at the heart of our objection today, the investigator relies on evidence that is either factually inaccurate or unsupported by applicable law to overcome respondent's non-discriminatory reason for the discharge. First, for the reports of sex discrimination retaliatory discharge claim, the commission should affirm the investigator's finding that the souring of relationships beyond repair was the real reason for the termination and should not assign weight to the comments by non-decision makers cited by the investigator or the factually inaccurate timeline of events, including the decision maker's role in those events, leading up to the termination. Second, for the discriminatory discharge claim, the commission should affirm the investigator's finding from the other claim, again, that the souring of relationships with supervisors beyond repair was the real reason for the termination and not assign weight to the stray remarks by non-decision makers or the gender-neutral stereotypes cited by the investigator, which are not valid evidence of sex discrimination. To quickly address each in turn, beginning with the retaliation claim. The retaliation claim, the legitimate non-discriminatory reason for the termination was not overcome by the investigator's reliance on comments by non-decision makers and particularly the omission of relevant comments by the decision maker. The First Circuit precedent leaves no room for doubt that statements made by non-decision makers are not sufficient to establish pretext or retaliatory animus. Here, the executive was the decision maker, executive being the term used in the investigator's report, making the investigator's reliance on a non-decision maker's handling of an HR investigation and another non-decision maker's discussion of complainant's report at a November meeting an inappropriate basis for establishing pretext. In addition to relying on those irrelevant facts, the report omits executive, the decision maker, explaining at his investigative interview that there was reports from nurses of a toxic workplace being created by a complainant. Those the executive statement is supported by documents in the record, particularly witness statements from the HR investigation into complainant's complaint of sex discrimination, where it says, and I quote, she was out to get admin, and also that she was creating, again, direct quote, a toxic workplace. So not only does the executive statement at his investigative interview, further support the legitimate non-discriminatory reason for the termination, it also is supported by other documents in the record, none of which were included in the investigator's final report. The investigator also relies on an inaccurate timeline, namely that the souring of the relationship beyond a point of repair happened by the time the decision maker got involved. And more than that, on November 9th, the same day the complainant submitted her written sex discrimination report to HR, was the same day that complainant emailed the chief, regional director, and medical director that she had lost faith in them, would no longer cooperate with them, and instead would go to the female lead physicians for support. So the investigator's retaliation analysis, therefore, is premised on a inaccurate, factually inaccurate timeline, showing that when the investigator does kind of concede and find that things got to a point beyond repair, was indeed earlier to or at the same time that the report was first made, that is kind of the setup for this retaliation claim. Now turning to the discrimination claim. Again, the investigator relies on stray remarks by non-decision makers. There's nothing in the record linking the decision maker, the executive, with such stray remarks. The stray remarks, as we walk through in our report, are in fact attributed to predecessor, chief, medical director, and the HR rep who conducted the investigation, none of whom were the decision makers, and none of those comments support a finding that executive actually relied on gender when making the termination decision. Furthermore, the reliance on those comments as stereotypes does not comport with the investigator's other finding on the sex discrimination in the terms and conditions of employment claim, that investigator based in part on her finding that the complainant failed to connect the stereotypes associated with women who report their concerns. I'll repeat that. Failed to connect the stereotypes associated with women who report their concerns to any difference in treatment. But then here, determined that that was not the case. So neither party, importantly, in today's commission meeting is challenging the investigator's no reasonable grounds finding on the sex discrimination in terms and conditions of employment claim. And next, to try to again overcome the legitimate non-discriminatory reason for the discharge, when it comes to the discriminatory discharge claim, the investigator relied on stereotypes that are not valid evidence of sex discrimination under applicable law. To establish a gender stereotyping claim specifically, the investigator needed to show that that complainant either conformed or failed to conform to some valid stereotype or stereotypes attributable to gender. Here, by contrast, the investigator cites a series of gender-neutral descriptors like toxic, erratic, lacking in rational judgment, unstable, etc., as examples of negative stereotypes associated with women who report concerns, despite the case law telling us that terms like those are not gender-based and thus do not support an inference that the executive or anyone particularly viewed complainant's discordant relationship with her supervisors as being tinged with a sex-based bias. And not only are these gender neutral characterizations, these characterizations also squarely align with the legitimate non-discriminatory reason for the discharge that the investigator credited for the patient safety retaliation claim. In summary, we ask that the commission affirm the investigator's finding that the souring of relationship with supervisors beyond repair, which negatively impacted the work environment, was the exclusive motivation for complainant's termination, and that the facts cited by the investigator to challenge said reason as pretext are factually inaccurate and unsupported by law, making a no reasonable grounds finding proper for these claims. Thank you.
Thank you, Attorney Weisberg. Questions from the commission? Seeing none, you'll have 2.5 minutes when we come back to you.
Barb,
Yeah.
Yeah,
David.
thank you. Attorney Weisberg, I mean, you say several times that the comments by non-decision makers are not relevant at all to the decision maker, but the decision, I mean, the argument proves too much. The decision maker is basing his decision on the environment as he hears it being described. I don't understand how you can say that those are not relevant. What evidence does the decision maker have other than the reports of the environment?
So the stray remarks that are being kind of just attributed to respondent generally, and the idea of those having had any kind of relationship with the reasons for the termination itself. So those stray remarks, as the investigator found in her report, were made by each one was made by a different person at a different point of time under different circumstances. And there's not anything that even suggests that the decision maker knew those stray remarks were even made, or how much he was really clued in to, you know, kind of the full underlying facts of the HR investigation into her complaint of discrimination in the workplace. So not only, you know,
I hope he was clued in as to what the environment was and what the basis of it was. Otherwise, he wouldn't have had any basis for his decision.
yes, but not all of those comments that are now being cited by the investigator in her report, those stray remarks, were in fact part of that the basis for complainant's report about sex discrimination in the workplace. And if I insinuated otherwise previously, I misspoke and I apologize. Pardon me. When it came to the decision maker's involvement, the decision maker got involved first really through an October 28th email that complainant sent to senior leadership saying, you know, in short, hey, I've been bringing these issues forward. I no longer have faith in my immediate leadership team to bring these things up the chain of demand. I think it's wise to escalate it, so I'm escalating it to you. She escalated it, and then between the escalation email, which was October 28th, and the November 14th meeting, there was a series of events that started to kind of set things in motion. She started saying, using very inflammatory language, things like neglect, accusing at a meeting with the decision maker present, accusing leadership of not caring about babies and children. These type of straw man arguments, while meanwhile, the senior leadership, the decision maker, the executive, did acknowledge at the November 14th meeting that he understood that middle management was looking into her issues and working to resolve them, but still she was using this inflammatory language. And at that point, she had already made clear, which had been then informed to the executive, that she had no intention of cooperating with her immediate supervisors at that point. She was not going to work with them. She's only going to work with female lead physicians, and she didn't have any intention of kind of finding another path forward that involved cooperation with those individuals.
Okay.
Any further questions? Yes, Commissioner Douglas.
Good morning. Morning.
Good morning.
Happy Monday. So I thought I heard you say that the stereotypes referred to in the report were gender neutral. I heard you say that a bunch of times. Am I understanding correctly that it's your contention that all of these stereotypes referenced in the report are in fact gender neutral?
We concede in one footnote that emotional is a stereotype usually associated with women. Other than that, the case law does suggest that all the other terms are gender neutral, and that there's nothing that, you know, allows us to ascribe them particularly to a single protected characteristic. And I think more than that, what's important here is that the investigator's finding on the sex discrimination in terms of conditions in employment claim, where the investigator specifically finds that the complainant has failed to connect those stereotypes with any difference in treatment, and that she had failed her burden on that point. But then kind of changes things around when it comes to a different claim, and we are asking, you know, for the commission to reconcile that given the totality of the evidence and everything in the report, which we believe leans in our favor.
Right, yeah, I noted that also. But getting back to the stereotypes, right? So we have this emotional thing, which you concede is not gender neutral. You know, we've got references to being a Disney princess here, which is, you know, troublesome. And then what we have is an investigation that reveals that complainant's coworkers don't feel that she conformed to this stereotype. She wasn't overly emotional. She was, to quote the report, assertive, clear-headed, sharp, et cetera, right? So there's this stereotype being ascribed to her, right? Which we agree is not gender neutral. And then we have sort of a dispute as to whether or not she fits that stereotype. Now, isn't that enough for us to find reasonable grounds for discrimination?
No, and the reason being because the only stereotypical word would be emotional. The comments that you're referencing about clear-headed, those were declarations by colleagues. And this is all boils down to not how she acted with patients, not how she acted with peers, but how she acted with her immediate supervisors. That's the discordant relationship at issue, the one that the investigator recognizes as being at a point beyond repair when it came to kind of the events leading up to termination and what was used to justify it. And in that set of circumstances, it wasn't because, she might, I think the language in the report even says like she believed that she was perceived as being overly emotional, but there's not language that says, that quotes anyone besides Dr. Baker, and he doesn't call her emotional. He says she uses a more emotional approach, but there's no kind of name calling in that vein. I think the important distinction here is that the evidence shows, it's all within the report for us, that she was these other gender neutral stereotypes. She was erratic. She was lacking in rational judgment. She was insisting on following up, I think it was the first or second footnote, on a patient safety issue that 2 times over 2 years had been investigated and deemed resolved, and she kept going back. And same thing, there was another instance with a compensation error, and she was fully clued into how it was resolved, an apology was made, and she still wasn't satisfied. So these terms, obsessive, and other terms that are, we believe, incorrectly ascribed as being gender motivated or gender tinged, are neutral. And not only are they neutral, they're accurate, and they reinforce the legitimate non-discriminatory reason for the termination.
Okay. I have more, but I understand where you're coming from for now.
Any further commission questions? Yes, David.
Yeah, Attorney Weisberg, what do you make of the record of employment from 2017 to 2022? As I understand it, is without incident, right?
Yeah, I'm very glad you mentioned that. It is. She was doing a great job in her job as a provider, and she was doing a great job in her managing physician role, which she started about 2 years, maybe 2.5 years prior to the time of termination. There was something that went on where within the fall of 2022, she just brought a different version of herself to work. We're not saying that this was always the case. Completely different. We're saying that she went on leave. There were some other factors going on. Whatever it might have been, we don't know. We didn't experience whatever she experienced. She just came back to work a different person. There was a little bit of, we were clued in a bit to this as to what might have been the reason at the IRC, where she, in the course of testifying that, it wasn't the reasons that we say it was, that why she returned to work a different person, she actually says the very point we've been making all along, and I quote, here's the quote. "I think the only thing I could say is that my dad dying made me realize how important it is for families to have access to people who know them, because my dad didn't have a primary care doctor. And I just thought, wow, this is really hard to navigate, and primary care doctors are just really important, especially for people with chronic health issues, and we weren't accessible. So I felt like it was important for me to share what I was seeing with who I thought was going to be a neutral party," end quote. And again, she was on leave in part, there's several different things, including health issues going on at the time, that before returning to work in the fall of 2022. One of those things was also the death of her father. And we've been saying all along that she came to work a different person. There weren't issues. People enjoyed working with her prior to that point.
Isn't there a change in supervisors, in personnel that she's interacting with?
No, not during the the entire time of her managing physician role. She reported to the same regional director And medical director is this dyad split between administrative and clinical side, who then report to a chief medical director of internal medicine or primary care, who then report to a chief physician executive. And that dyad was the same throughout her managing physician role, including the people who chose to, offer her that role in the first place. They never changed.
Okay.
Further questions? Being none, you'll have 2.5 minutes when we come back to you, Attorney Fox. Would you like to recommend?
I would, 2 minutes for refill, please, thank you.
And I'm sorry, what's the name? Attorney
Maria Fox, yes.
Maria Fox, thank you.
Ed, can you see our room okay?
Yeah, she's cut off at the podium, right through the middle of the podium, but it's fine. I know she's there and I can see her.
Shall I stand somewhere else?
Presenting.
Or?
No.
See,
Okay.
No.
got a cockeyed there.
There
Yeah,
we go.
that's perfect. That's
Okay.
perfect.
Newbie with the camera, sorry.
Okay, all right, thank you.
Great, you go ahead.
Good morning. My name is Maria Fox and I represent Dr. Gretchen Pianka, who's here today. We are asking the commission to follow the investigators' recommendations on the sex discrimination claim regarding her termination, as well as the MHRC retaliation claim regarding her termination. We're also asking that the commission find reasonable grounds on the Whistleblowers Protection Act claim. Dr. Pianka has been a pediatrician for over 20 years. She worked at Central Maine Pediatrics, also referred to as CMPs, for 5 years, 2017 until November 22nd, 2022. She served as managing physician of CMPs for the last 2+ years of her employment. CMHC had reservations about making her managing physician because of this perception of her as an emotional person when she raised some issues regarding patient care and safety. They made her managing physician anyway, put her on a 6-month probationary period, gave her compliments about her leadership and about her work as managing physician, but never removed her from the 6-month probationary period, never allowed her the same autonomy as her male predecessor, despite the fact that she had, even at 2+ years in the role. This was a fact that the male predecessor confirmed, that there were differences in the way that they were treated. This left Dr. Pianka hamstrung in managing her department. And there were some serious issues that needed attention. There were some patient safety issues. A couple of examples: near clinical misses due to CMHC's decision to remove an after-hours call system staffed with triage nurses. This impacted pediatric patients more heavily than any other patients in the hospital. Adoption of a care model that left babies and children with disabilities to have to go to the emergency department for nebulizers rather than obtaining access to that respiratory care in the clinic like other pediatric patients could have. So after months of attempting to work with her mid-level managers on these and other issues, and because of the comments, there were some gender-based comments that were made to her, the difference in treatment that she saw of herself and the male predecessor, she thought, look, if my gender's getting in the way of taking care of these pediatric patients, I need to do something about it. So she went to Human Resources and lodged a sex discrimination complaint. And this was about a month before she was fired. She also simultaneously sent a letter to executive and to chief operating officer, specifically calling out the patient safety concerns that she had. Within 2 weeks, executive ordered Dr. Pianka and her team to attend a meeting with him, the chief people officer, medical director, on November 14th, 2022, not to discuss the issues that she'd raised in her October 28th letter, but specifically for him to decide whether or not to shut CMPs down altogether. Dr. Pianka attempted to engage the senior leadership at that meeting regarding the patient safety concerns. She prepared and presented a 2-page chart with her outstanding concerns that were shared by other providers in the department, along with some reasonable proposals for solutions to where they could get to a better place. But executive didn't want to talk about the proposed plan or solutions to any of these problems. He refused to engage in any of that. The chief people officer at that meeting publicly questioned Dr. Pianka about the sex discrimination claim that she had made to Human Resources. Executive during that meeting made clear his displeasure with Dr. Pianka's reports of discrimination, as well as her reports of patient safety issues. He said that if others felt that CMHC was discriminating against babies and children, quote, then we need to shut the practice down, close quote. Executive's singular focus was whether the pediatric providers could continue to work for CMHC without continuing to elevate these concerns, or if he should shut the place down. He said he could not tolerate this, quote, level of escalation of concerns. Commissioners, this is direct evidence of retaliatory animus by executive against Dr. Pianka for reporting discrimination and escalating patient safety concerns just 2 weeks before she was fired. He fired her. Executive ended the November 14th meeting, instructing the members of the group to call him, no emails, call him, let him know if they wanted to continue working there, and to let him know if they, quote, believe in the organization, looking for a loyalty pledge. Although Dr. Pianka timely relayed that she wanted to continue working for CNPEDS collaboratively, within days, on November 22nd, CMHC told her that it was electing to terminate her employment contract without cause. Without cause. Respondent claims it's undisputed that Dr. Pianka's attitude towards her supervisors had soured and that this negatively impacted the work environment, and that's the reason that she was fired. This is false. This is pretext. Dr. Pianka was absolutely willing to work with these mid-level supervisors, and she told executives so after the November 14th meeting, just as he requested. Executive made the decision to terminate Dr. Pianka based on the knowledge that he had, and according to respondents, based on an investigation, a so-called investigation that Human Resources had conducted. This investigation was clearly ends-driven. Human Resources was supposed to be investigating Dr. Pianka's sex discrimination claim, but she added to it a misconduct investigation without telling Dr. Pianka that that was happening, without interviewing Dr. Pianka about the allegations about the supposed misconduct, without interviewing key witnesses, including female providers in the department, 2 of whom provided statements in this case supporting Dr. Pianka's claims of gender bias and retaliation. The witnesses she interviewed included these mid-level managers, each of whom made comments evidencing their gender bias against Dr. Pianka. There's no analysis or report analyzing the conclusions, but a grouping of notes and emails, some of which pertain to a different provider against whom some nurses thought this different provider was being toxic. Made it look like this was about Dr. Pianka, but it was about a different provider. And Human Resources, in her own notes, included a reference to Dr. Pianka being too emotional and potentially unfit for duty. HR also wrote that they recommended termination in part to what they called, quote, excessive and continued emails that Dr. Pianka is sending to our senior leadership team. And these referenced emails were hardly excessive, and they all relate to Dr. Pianka's good faith concerns about patient safety. Terminating Dr. Pianka for escalating patient safety concerns to senior management is completely inconsistent with CMHC's own policies, which say that if you have patient safety concerns, you elevate it until you are satisfied that the full importance of the matter has been recognized. We are asking that the commission find reasonable grounds on all 3 of Dr. Pianka's termination claims. Thank you.
Thank you. Questions from the commissioners?
I'm sorry, that I couldn't hear that, whatever was just said.
I just asked if there were any questions from the commissioners.
Thank you.
Sorry, I'm not used to talking this much.
Yeah.
That's good.
Yes, Commissioner Dean.
Attorney Fox, you said that her discharge was labeled to be without cause. What's the significance of that?
Well, the significance of that is that they're essentially admitting that they don't have a good reason to fire her. They just don't want her around. I think it adds to the pretext claim. The definition of cause in her employment contract includes misconduct for which she was being investigated. It includes conduct that would be inconsistent with CMHC policy. So if they had cause, they would have terminated her contract with cause. So it's an admission, in my view, that
Okay.
they didn't have a good reason.
And then you say that they're really saying that there was misconduct and being too vigorous in escalating the claims and the demands about the safety concerns, the lack of the nebulizer, the lack of the triage procedure, that she was too aggressive. Is that what you think they're saying?
I guess what I think they're saying is that they are using the manner in which she was escalating concerns as a basis to terminate, when in fact it is because she's elevating these patient safety concerns. They want her to be quiet. They want her to step back. They do not take her seriously because she is a woman, and they think she's making too big of a deal out of these issues. They want her to be quiet. And that is
Well, they want her to be quiet. They want her to be quiet, and she's making too big of a deal out of it because she's a woman is clearly relevant and sexual discrimination. I'm inclined to be sympathetic to the fact that the business decision about whether they can afford a nebulizer or whether they can afford to support the continued nurse triage procedure is an economic staffing decision, and they're hearing the complaints and they're saying they can't do it, which is, to me, that's the reason the investigator finds no reasonable grounds on those things. But I am left with being sympathetic to finding sex discrimination as being a factor in the ultimate discharge. Okay. I guess there's no question there.
There wasn't a question. May I address that statement? Or
Mr. Davis?
Sure.
okay.
Yes.
It wasn't that they said to Dr. Pianka, we hear your concerns about the nebulizers. We hear your concerns about the triage nurse. We simply can't afford it. We think that this meets patients' standard of care. There was no discussion like that. The executive came into that meeting saying, I am here to figure out whether I'm going to shut the department down. It had nothing to do with, can we afford nebulizers? Can we afford a nurse triage? So I just want to make that clear.
Okay. Thank you.
Thank you.
Mr. Douglas?
So I thought I heard you say, in terms of the reasons why complainant was terminated, that one of the reasons was for sending excessive emails. Did I hear you say that correctly?
Yes.
And these emails that she was sending, obviously we're talking about the retaliation claim here, had to do with these issues that she was having, the whistleblower type allegations. Am I understanding that right?
That's correct. So HR in their report said that in part they're recommending termination because of, quote, excessive and continued emails that Dr. Pianka is sending to our senior leadership team, close quote. If you look at what correspondence she was sending to senior leadership team, it included patient safety concerns.
Right. And I think that respondents counsel is going to say that these allegations were investigated and findings were made, et cetera, et cetera. But I also heard you say, if I'm not mistaken, this was the policy, right, of this organization to continue to escalate things in your sense.
Yes, and I'll just add, so there in the November 14th meeting was recorded. And so you can hear them talk about at one point reference to the nebulizers that the chief medical director was saying. We handled that. Dr. Pianka was referring to a different issue that was more present that they had not addressed. It had to do with, they had established a separate clinic for nebulizer treatment that was recently slimmed down to only providing care for 1 hour per day. And it was October, they were heading into the respiratory care season when they were going to be seeing a lot more children with respiratory issues. And so there was an issue right there. And there were email in the record showing her trying to work with her mid-level managers and trying to help the non-clinical regional manager couch the information for senior leadership in a way that really explained from a pediatric clinical perspective why this was so important. You do see in the record that unbeknownst to Dr. Pianka, she did elevate those issues the way Dr. Pianka in Dr. Pianka's language, almost verbatim, that I think assisted in fixing that problem, but they never told her about that. And so she's, you know, right as she's getting fired, they didn't tell her that they were doing this on the one hand. So she escalated it because she was concerned about the safety issue. They do have this policy, and she got fired.
Just one more question then. This business about her predecessor being treated differently, right? Like he's given more latitude, more leeway, she's under more strict supervision and so on and so forth. But the record appears to clearly show that he had more experience in the role. I saw something about 15 years of experience. So I mean, isn't that a credible reason to treat them differently? I think up to a point, maybe.
Certainly up to a point, but after 2+ years in the job, that she's not allowed to do the same job as he has. I mean, yes, he had more experience, but he himself identified and said that she wasn't being treated similarly in sort of very basic ways. And, you know, he was really allowed to more nimbly run the department. He would gather up providers and have meetings, and they would troubleshoot things that were happening. And then if they'd work things out themselves if they could. And they would only go to administration if they needed to do that. She was under the thumb of these various, you know, clinical, non-clinical people who were mandating that she come to meetings. Sometimes they wouldn't show up, mandating that she sort of copy them on email. There was a lot of inability for her to act nimbly. So it made it very hard for her to manage the department. So we submit that, yes, her male predecessor had more experience, maybe on some grander scheme, but she wasn't a newbie. She should have been off her 6-month probation long ago.
Thank you.
Further questions for Attorney Fox? Being none, you'll have 2 minutes and 10 seconds. We come back to you. Attorney Weisberg, you have 2.5 minutes.
Thank you. To address a few of the points that Attorney Fox has raised. First, surprised to hear some of the emphasis on this alleged comparative difference in gender between Dr. Pianka and her predecessor, given that complainant is not challenging the finding of no reasonable grounds for sex discrimination in the terms and conditions of her employment. Second, it's very telling to us that that Attorney Fox does not exclusively relies on the recording of the November 14th meeting in making many of the points she has raised today. I re-listened to that recording last night, and it is like 2/3 of it you cannot hear. It's inaudible. The only voice that comes through clearly at any point, the clearest voice, is Dr. Pianka's, because she was on it via Zoom and she was the one recording. She was recording it from California, a 2-party consent state, and she was doing it of all these other providers, and you cannot make anything else out. They even acknowledge in their final submission of evidence that they had an unofficial transcript. It was a transcript prepared by Dr. Pianka, and it shows all the gaps. And this is partially, I assume, why the investigator found that the report, she doesn't assign as much credence to the transcript in that meeting as perhaps complainant does, and it's not as clear cut as complainant might suggest. When it comes to the triage services, this is something that's been asked and answered. Respondent in its position statement provided exhibits V and W that squarely rebut the allegation that this was not attended to. There are emails directly with the complainant that show how this was handled, the research that was done, and exactly why they were not able to move forward with it for business reasons. When it comes to the code of conduct, I want to distinguish an important point. You are supposed to escalate an issue if it has not been given sufficient or appropriate attention. For the vast majority of the patient safety concerns Dr. Pianka raised, they were sufficiently and adequately addressed by supervisors, but as the investigator rightly pointed out in her report, they might not have been handled to her satisfaction, but it doesn't mean she didn't know how it was handled, whether they weren't resolved. Thank you.
Wow, with 1 second to spare. Questions from the commissioners? Yep, go ahead, Commissioner Douglas.
I'm just struck by something that Attorney Fox said on the retaliation claim. you heard me ask her about these excessive emails being a sort of a basis for termination. That seems really problematic to me for you. And I just wanted to give you a chance to sort of respond to that.
Sure. So the terminology of excessive emails was used in the HR rep's conclusion at the end of the investigation into her complaint of sex discrimination. And the email trail record, I mean, this is partly why we had, I think it's 150-page position statement with exhibits. There were a lot of emails, and that increased traffic happened right when she came back to work and came back with a different version of herself. She was sending email after email about issues that had been resolved time and time again, and she would not let it go. And she kept re-raising it, and it got to a point where there's nothing else her middle management could do. And then we get to a point in that fall of 2022 period where not only was it constant emails about various matters and following up even when they have been resolved, it was also name calling. So one of the points that Attorney Fox mentioned is that Dr. Pianka arrived to the November 14th meeting with a chart of reasonable recommendations for how some of these issues would be solved. That chart accuses her direct supervisors of neglect in the first sentence. I wouldn't call that a collaborative framework trying to invite people in to have a productive discussion. And one of those reasonable recommendations was her personally paying out of pocket for the department's triage service. Forget the HIPAA issues that would come with that. That was a non-starter from the beginning, the idea of her personally financing a hospital mechanism like that. So there's a lot to be said about the excessiveness coming in large part from the unreasonableness of why things were being brought up again and again, things that had been resolved so many years prior, the reply all to the email of the initial extension of the managing physician offer 2 years later, claiming that maybe it had something to do with gender. Out of the blue, 2 years later, after successfully and being acknowledged by her male supervisors as doing great in that role. Again, there was something that happened in the fall of 2022, and it was a different Dr. Pianka than everyone had gotten to know.
So you said something about 150 pages, I think. Can you just give me like the 2-minute rundown in terms of how many emails are we talking about, right? Are we talking about an email a day? Are we talking about an email a week? Are we talking about 5 emails a day? Just give me your best. I don't see that in the record that I have, so.
Sure. So attached, one of the things that we did in the position statement is we outlined for every concern she raised exactly how it was addressed and resolved or being attended to by her immediate supervisors. And in terms of email traffic, we've not had the benefit of doing a full ESI exploitation discovery on this process. So I can't give you an accurate estimate and the exact volume, but based on what we've produced and we've seen and we've exchanged throughout this investigative process, we're looking at, I think it's better to say per issue. How many emails was she sending on a single issue and how many was she sending after it was resolved? This chart she brought to the November 14th meeting. That's an example of her reiterating the same points that had already been asked and answered in meetings with her immediate supervisors, emails with her immediate supervisors, follow-up emails with her immediate supervisors, escalation email to senior leadership that prompted this meeting. And I would also argue that the suggestion of closing down the practice shows exactly how seriously respondent takes the concerns that she was raising. But I apologize that I can't give a more precise estimate, but for us it is excessive per issue, I think, is the root consideration here.
Well, that's helpful. Thank you.
Any further questions for respondents, council? Seeing none, thank you.
Thank you.
Attorney Fox, you have 2 minutes and 10 seconds.
Thank you. Just a couple of points. In terms of the decision for us to not challenge the different treatment claim, it really had more to do with adverse action, but it is clearly evidence that we think is very helpful in understanding the termination. With regard to the triage service, the issue was not cost. The respondent erroneously wrote in their response that this was not a safety issue. And Dr. Pianka had been collecting some information about why the particular triage service that did not have a nurse who was able to answer the calls were posing a grave safety issues for pediatric patients, especially given the volume of calls that these providers were getting. And so it's really delayed care, which can result in fatalities and really bad outcomes for pediatric patients. And so it was couched as if this was not a patient safety issue, but a provider preference, which was missing the mark. And the same issue with the nebulizer treatment, that some of these issues were being elevated, but were kind of missing the mark from a pediatric clinical perspective, which was what Dr. Pianka was trying to raise. With respect, Respondents Council is completely exaggerating the number of email that she sent on these issues. There were a handful. And she, after 2.5 years on the job and trying, on the nebulizer piece, she had been trying for 4 months to be heard on how this was, going to disparately impact the babies and the children with the disabilities to have this model. It just wasn't getting through. And then finally, what did get through was actually her pressing this with her mid-level managers and them finally couching it in the clinical way that she had crafted, but they didn't bother to tell her. They didn't have the level of respect for her to include her in what they were transmitting to senior leadership. And then they take credit for, well, she's bringing these things up, keeps bringing these things up that we're taking care of. So that's completely disingenuous. And then in terms of, I'm past my time. I'll stop. Thank you.
Questions from the commissioners?
Said a handful. Sorry.
We should have an actual number, but
Yeah. Are we talking about 5? Are we talking about 20?
I would say somewhere in the middle of that would be my estimate. We're not talking about hundreds of email. We're not talking about email about the same thing. And that would include email regarding a topic where there's some back and forth. But she had one report to Human Resources regarding the sex discrimination claim, and then she followed up per the Human Resource Manager's directive to put things in writing. She sent one letter, October 28th, to senior leadership. She had email between her and her mid-level managers, where again, they're refusing to tell her what it is that they're talking to with senior leadership about these issues that clearly need a more pediatric clinical focus to be able to get through and make the changes that she thought were necessary for patient safety.
And these emails, am I understanding right that we're talking about like a 2-3 week period, something along these lines?
There is it's a 1 month period from when she goes to Human Resource to when she's terminated. And there's the meeting in between, the meeting with executive and the team in between.
Thank you.
Any further questions?
Yes, I'm a little confused. You're not pressing the no reasonable grounds findings on the terms and conditions?
We did not object to that.
You do not object to that.
We did not object to
4 and
that.
5.
Sorry.
Right. Okay. Got it. Thank you.
Thank you.
You objected to 4, just not 5, correct? Or is it the other way around?
Well, 4 and 5
but
are together.
No. They're together because there are no reasonable grounds, but the objection was with regard to the WPA, right? Not the
Correct.
discrimination. So question is finding number 4 in the recommendations has not been tested at, number 5 has.
Okay, number 5 is being
Yeah.
pressed. Okay.
All right. Any further questions? Thank you.
Thank you.
We've heard from the parties. We will now hear from Investigator Jane O'Reilly.
Second to Michael up here too.
Yeah.
Good morning, commissioners. My name is Jane O'Reilly and I was the investigator on this case. I'm going to start with the email question because I do actually have the emails in the RA, respondent answer to the complaint. I would agree with the contention that the term excessive is not accurate and not supported by the record, given what respondent provided as the excessive emails. I've seen excessive emails in our investigations here. This does not meet that standard. I think one of the examples to give, to give credit to both sides, there is, I think, a particular email exchange which illustrates one of the things that Respondents Council was saying this morning, which was sort of a continued back and forth that felt beyond, the issue had been resolved, and that was regarding a provider who was having issue with their pay. There was a mistake made in the provider's pay that complainant was advocating for them for. And respondent had sort of, this middle management team had responded and said, yep, we know it's a mistake. It happens. She didn't feel that was taking responsibility for the action. There was sort of a back and forth about whether they were eroding trust, whether there was responsibility. And I think that email exchange is in here and has maybe 3 or 4 back and forths after the sort of initial response. So whether or not that's excessive or whether or not I certainly, in reading none of this, felt excessive was an appropriate term. And this is the entire submission. Most of this is policies. And I think there's a few emails here at the front, if you want a visual. There's a few emails here in the front about the initial sort of giving her the position. That's A and B right up here. And then there's a series of emails at the back that are about the different, here we go, sort of right in here about patient safety concerns here. We've got some little pockets of emails, but nothing that I would determine excessive. I have a lot of thoughts about this case. It was a very difficult one for me to investigate. I think a lot of times I, really feel confident at the end of my preliminary investigation that I have everything that I need. And I did at this one, in the sense that I felt it was either stop here or take months and months and months of interviewing every single staff member and everybody's impression about everything. That's sort of the deal with a lot of sex stereotyping cases, right? You're sort of dealing with what you have in front of you, and to really, really get into it, you probably have to interview everybody about their impressions. I was just gonna stick to addressing why I found differently on the terms and conditions and the discharge for sex discrimination, and then I can answer questions. I think that makes the most sense. However, if there was something specific you wanted me to talk about, before you have specific questions, I can talk about that too. So the reason that I did not find sex discrimination in the terms and conditions, but did find sex discrimination on the discharge, really has to do with the types of behavior that was being stereotyped. So when she was first hired into the position, I did not find it credible that the sort of reservations that everybody had, that she was already viewed as sort of an overly emotional person. There was definitely some conflict between regional directors, so the administrative supervisor of the dyad pair, not her clinical supervisor, but the person who did the administrative functions. Prior to this and throughout, I was unable to interview her. She no longer was employed or respondent. I did reach out. That was unfortunate. But there was clearly something, she was the one who sort of had some reservations that were adopted by the rest of the team based on their trust in regional managers' judgment. However, after that, for those period of 2 years, everything was fine. There were some differences in how she was managed in the position, but I did not see that as tinged by any kind of stereotypes that she wasn't trusted or that she wasn't seen as capable because she was a woman. However, when there started to be conflict between her supervisors, I felt that the response to that conflict, the response to that behavior, the response to her continually bringing up these issues did have those sex stereotyping terms, in particular, based on a lot of comments made by HR, which was when I first got the response from respondent and I asked who the decision maker was, executive was identified as the decision maker in consult with HR, including the HR who did the investigation. So I knew that the perception of her as a whole and the perception of how she was viewed as a person who maybe the relationship couldn't be salvaged, was based in part on some stereotypes based on her sex, given what I had in writing and the comments that were made when talking about her behavior. I hope that answers that question about why, because it looks weird on the front. And again, I struggled with this one. Same with the differences between the patient safety versus the sex discrimination claim, a lot of the same reasons, right? The patient safety concerns, as you noted, they may not have been communicating with her as effectively as she wanted, but there's strong evidence that not only were these issues existing before she took on the role, in particular the nebulizers and the negative pressure required to run the nebulizers. And I'm sure I'm saying that wrong medically. I'm so sorry, Dr. Perry. I tried really hard to understand the medicine and I'm struggling. But, you know, given what was being requested and what was needed, it appeared to me from the record that what they had problems with was the tone she was using, not just that she was escalating them, because they agreed, you know, if things aren't being resolved, you can take them up. But when she escalated them, they had a tone of, I don't think you've been told this yet. You must not have been told it accurately. I don't think you've been told how important this is. Things that directly affected, you know, things that were maligning her intermediate supervisory group in terms of their efforts, right? So they felt personally that their efforts were being not only ignored, but diminished by her reports to senior leadership that this just must not be getting heard because nothing's being done. So that's why I found differently on the sex discrimination claims versus the patient safety claims, because I didn't think that was the issue if she had just reported those things. But then when it became an issue of sex discrimination, I think then again, this whole issue of she's making mountains out of molehills, she's erratic, she's overly emotional, she's, you know, making problems, became more of the issue. So any questions?
Such a deal.
Questions for Jane? Seeing none.
Okay, thank you.
All right, we've heard from counsel, we've heard from the investigators. And at this point, we're looking for a motion. There are 4, count them 4. Recommended findings. You can take them however you want. Go ahead.
Okay, again,
Oops,
low hanging
we
fruit.
need a motion first.
I'm sorry.
No, go ahead.
We're just gonna clarify,
Oh.
1 and 4 are not voting, on, right? Those are the 2.
You are voting on 1, 2, and 5.
Oh, okay, then,
Respondent challenged both of reasonable grounds.
Sounds backwards. So.
There are a lot of findings. So 1, 2, and 5 are in play. We need a vote on 4 anyway. So
okay, then. So,
It's 1, 2, 4, and 5.
1, 2. Yeah,
we need votes on 1, 2, 4, and 5, but 4 has not been challenged.
right,
So
okay, so.
yes,
Trying to make sure that we.
yeah.
Alright. I make a motion that there are no reasonable grounds to believe that Central Maine Pediatric Central Maine Healthcare discriminated against Gretchen Bianca on the basis of sex, terms and conditions.
We have a second.
Second. Second.
We've got a motion and a second. Any discussion? Seeing none. We're gonna call for the vote. This is just the sex terms and conditions claim. Commissioner David,
Yes.
Commissioner O'Brien,
Yes,
Commissioner Douglas.
Yes.
Great. 1 down.
Well, I'll make a motion that there, for number 1, that there are reasonable grounds to believe that respondent discriminated against plaintiff on the basis of sex for the discharge claim.
Have a motion. We have a second.
second,
Been moved and seconded to find reasonable grounds to believe that complainant is discriminated against with regards to her sex in her discharge. Commissioner David,
Yeah, discussion or we're voting, yes.
I'm sorry, discussion if needed. I'm gonna forget that a lot.
Well, I think we're down to the as likely as not, and there's enough strong suggestion of improper sexual bias here for me to think that that's a plausible claim, and it's as likely as not. And I don't quite credit this being a different person when she comes back. So I'm going to vote yes, that there are reasonable grounds.
Additional discussion.
Yeah, I agree with everything that Commissioner David said, and I'm just looking at the report and, this paragraph C on page 10. The investigator says that, the most compelling thing is that they characterized her as being unfit for duty and immediately escalated to recommending that she be discharged. At no point do they question her judgment as a physician or a patient care. You know, the only reason for the recommendation, according to the investigator, was reliance on the perception that she was too emotional. The criticism of management was based on her own emotional state. And so getting back to what Commissioner David said, I think the even chance standard gets us to a finding of reasonable grounds on this claim.
Further discussion? Okay, calling for the vote, Commissioner David,
Yes.
Commissioner O'Brien.
Yes.
Commissioner Douglas.
Yes.
Okay. So the sex discrimination case, the claims are taken care of. We're looking for votes on the MHRA and WTA first with regards to discrimination and with regards to health and safety risks.
I'll make a motion on 2 that there are reasonable grounds that this was retaliation. Okay, so that's the motion.
So this is just number 2. So retaliation for reporting sex discrimination.
Just number 2, and I hear it failing for lack of a second.
No, I haven't asked anyone for a second yet. Do
Oh,
we have a second?
Second.
Excellent.
oh, okay.
Any discussion?
Yeah, I've had this problem before that the unlawful discrimination on the basis of sex is what we found was unlawful, and then retaliation on top of that. It almost seems like it's the same thing, but I guess I do see the difference that you could fire somebody and never have had the complaints being made. It's the fact that the complaints are being made that I guess gets us into retaliating for those complaints. So I think it follows with number 1 in this case, at least.
Further discussion? None. Okay, if you vote yes, you're voting in favor of reasonable grounds to believe that there was discrimination on the basis of reports of sexual harassment. Commissioner Davis.
Yes.
Commissioner O'Brien.
No.
Commissioner Douglas.
Yes.
Okay, so the finding is reasonable grounds. Okay, we're left with finding number 5.
And I'll make a motion that there are reasonable grounds to believe that Central Maine Pediatrics, Central Maine Healthcare retaliated against its complainant for engaging in WPA protected activity based on reports of risk to health and safety of others.
Is there a second?
Second.
Any discussion?
But this is the handful of emails conversation that we've been having, and it seems that respondent's counsel has conceded that one of the reasons she was terminated is because of these emails that she was sending raising these issues. And I think that there's evidence on both sides that these, as to whether or not these were excessive or harassing or anything like that, but I think that's a question for a fact finder trial. So I think that in terms of the even chance standard, I think this should be a reasonable grounds finding.
Further discussion then? Seeing none, if you vote yes, you are voting in favor of a finding of reasonable grounds to believe that there was retaliation on the basis of safety and health reports. Commissioner David.
Yes.
Commissioner O'Brien.
Yes.
Commissioner Douglas.
Yes.
Sorry, there was a surprise there. Didn't you cross things out? Okay, so the findings are reasonable grounds with the exception of finding number 4, which was no reasonable grounds. Thank you for your participation. You'll get a letter explaining next steps and confirming results of the hearing.
So can we squeeze in another case before taking a break?
I can't, sorry.
No, okay. 5 minutes.
I drank a lot of coffee, Ed.
I got it.
Thank you.
What do you know that we don't do?
Oh. I live here.
Let me get our parties up.
Okay, we'll call the second case on the agenda, which is Christine Duplessis on behalf of a minor child versus MSAD 52. It is a recommendation of no reasonable grounds, that we make a no reasonable grounds finding, and therefore we'll hear from complainant.
Good morning.
Good morning. You have 10 minutes. Would you like to reserve any of your time?
Yes, ma'am. Could I please reserve 2 minutes at the end?
Absolutely. I'll let you know when it's been 8.
Okay, thank you. After reviewing this material in its entirety, I can clearly see laid out that my son was having trouble with school and struggling with a learning disability, as is documented by his educational plan, Exhibit 2. He also missed school due to health issues. Into this figured endless bullying taunts and jabs about his race and sexual orientation that he was forced to endure upon entering Levitt Area High School, resulting in a less than ideal state of mental health and poor educational environment. Respondent seeks to paint my son as a problem kid, but he didn't have any issues in school previous to high school, and his trouble with classes indicate a lack of support academically as well as socially. Each child has a right to a free and fair education, and this was not provided for my son. One cannot expect a child to always be on their guard against bullying aggressors, yet simultaneously maintain an optimal learning performance. Additionally, my son was not respected and treated fairly by the student body in general, was picked on, not well liked, and therefore when issues came up for him, there were never any witnesses and no one to corroborate his recollection of events. Respondent saw this behavior, but did nothing to rectify the situation for him. This is why unbiased classroom and video footage is necessary to corroborate my son's experience. Also clear is that, as a parent, I have kept communication lines open to the school and advocated for my son's educational goals repeatedly. I continue to assert that the respondent discriminated against my son in the following ways. Other actors in the events described were questioned differently, prompted with leading questions, and believed without credible evidence. Considering the incident of 6/2/23, Exhibit 9, in the submission from the EdTech, the student in question is simply believed at face value with no credible evidence. The student is allowed to wander in late. By the EdTech's own admission, the student made comments about my son during class, and then that student's impression that my son and his friend were looking for her is needlessly included. The impression of this student is irrelevant and not able to be substantiated and only serves to color the submission against my son. The EdTech also states that she was able to back them out of the classroom. How? When the students yelling for my son and his friend to get out did nothing. This EdTech is then re-interviewed to give her a chance to say that she had no body contact with my son, as this is not explicitly outlined in the first statement, which does not conflict with my son's statement. The manner in which the witnesses have been questioned or prompted is strange, as is the information included as evidence. As the first witness described, they appeared to be looking for a fight. This is also speculation, not a pure description of actions. Then tacks on, EdTech never touched them at all, as if she was prompted with a particular question. A second witness is likely asked a leading question also, as her statement contains a similar answer. She never touched anyone. These statements are answer type statements, not typical of description of positive actions. He did this, she did that. If the EdTech had never touched my son, there would be no need to list this behavior or any other behavior for that matter as having not happened. Additionally, the video would have captured this physical use of force that witnesses may not have seen due to the EdTech's body hiding her hands from view. After this EdTech states that the student made comments about or to my son, the teacher's statement undermines this, Exhibit 9, where the student claims now that she didn't say anything to my son and never spoke to him, even though she did by the EdTech's own statement. Then, although her comments too about my son lie at the origin of this event, she is comforted by the teachers that she should not have allowed herself to get caught up in it. These bullying reports, Exhibit 9, place my son entering the classroom first to confront the student, but my own write-up of events from my son states that his friend entered the room first. Video footage would settle this, as my son's statement undermines the claims in this report, and neither my son nor his friend were ever interrogated on this point. Or if they were, the information is excluded from this report. Neither were these two witnesses even questioned concerning the ed techs pushing them out of the room. Nowhere in the report does it state that either child was asked if the teacher used force to remove one or both of them. Both witnesses had the potential to corroborate each other's recollection of events, but they were never given the opportunity or this information. If mentioned at the time of questioning, it wasn't included in the final report. Again, this entire issue would be completely resolved by either my being shown the classroom and hallway video footage any number of times I or the investigator requested it. Evidence of an incident is preserved as key to truth and could exonerate my son, yet I'm told it was not maintained. Yet we are all to believe that the video footage was viewed by the respondent only, judged to be of no interest to anyone, and therefore disposed of without ever sharing. This violates the rule of procedure and discovery, and I again request these videos are an adverse inference. The ease in which these videos could clear this situation makes it ridiculous that they would be hoarded and erased. Failing to provide evidence in the respondent's custody is in itself discrimination. I request all appropriate sanctions against the respondent and an apology for my son, as well as any other relief deemed appropriate in this action. Considering the incident of 3/3/23, student admits to making a slur concerning sexual orientation that was not directed at my son, but he overheard it. The mitigating language deflects culpability. A bullying comment was said about gay students in the presence of a gay student. Even if this student were quoting another, to voice a slur still constitutes a slur in itself. A friend of this student concedes that he might have said something about false eyelashes concerning my son's appearance, but this never pursued in the bullying report. Furthermore, nothing in the bullying report states that students can speak whatever slurs they wish as long as they're not directed at the targeted students. So whether it was so directed or not, this comment was indeed bullying and is not being pursued constitutes discrimination. Later in this bullying conflict, a second student threatens my son with physical injury. This is never treated with the seriousness it warrants, but instead, the summary of investigation finds that my son, because he confronted the students targeting him, was also found to be making threats, although there is no evidence produced that any threats were ever made by my son. After my son established boundaries of respect in his text, the aggressor ceased their threats. Both bullying comments and action were initiated against my son, but there was no punishment for either student involved, only removal because those students were under an IEP. Treating one group of students differently than another group is discrimination. The summary states that we believe that all three students played an active role, even though my son did nothing to these students. Nothing is said in this report of bullying student inappropriately contacting me in order to paint a mitigating picture of events. My son was a victim, yet these actions are not found to be bullying behavior, though they did create an intimidating or hostile learning environment and interfered with academic performance or ability to participate in or benefit from services, activities, or privileges provided by the school. His experience is not dignified with acknowledgement, and this is essentially my complaint. I do not agree with the findings of Drummond and Woodsum investigation report. I maintain that MSAD 52 discriminated against my son by not addressing his concerns adequately as being serious drivers in his psychological well-being by admittedly not using discipline fairly across the student populations and by excluding pertinent information in a timely fashion, including failing to question witnesses equally and fairly. It is furthermore stated by administration in an audio recording listed in evidence exhibit 8. The administrator admits there is an issue with bullying and quote, I need your help because I can't solve this by myself, end quote. A child is not, yes, ma'am?
That's 8 minutes. You can keep going. I just wanted to let you know.
Okay, I'm at the end anyway. I'll finish my last couple sentences.
Okay.
If it is furthermore stated by the administration in an, oh, I did that one. Sorry. A child is not in the position to assist an administrator in providing an optimal educational experience for all students when he himself is experiencing incessant discrimination. Administrators knew my child needed help and instead turned that around to my child not wanting help. Thank you.
Thank you. You'll have a minute and a half left when we get back to you.
Okay.
Any questions from the commissioners? Commissioner Douglas.
Yes, good morning. So I just wanted to make sure I understand that it sounds like, and I read your submission, it sounds like a big problem that you're having here is that you feel there should be video of some of these things, particularly your son being removed from the classroom. And you've asked for this video and it's not been produced.
Yes, sir.
Okay, all right. Is it your, and maybe this is a better question for the school district, but So your understanding this video would have audio as well, or do you not know?
I do not know. I don't want to comment on that. I'm not sure.
Okay, thank you.
Any other questions for complainants?
Yes. Yes.
Commissioner David and then Commissioner Brian.
Good morning, Ms. Duplessis. The investigator does find that there's a hostile environment, and your presentation emphasizes some of the inappropriate things that created that environment. The issue seems to be what the response was. You focus a lot on that single incident, but what is your complaint about what how the school responded to the situation? What do you want them to have done?
I think that if they handed out consequences more adequately, like the first offense, I understand wouldn't be a suspension or what have you, but I don't feel that they handed consequences out appropriately because the students that were doing the main bullying were under IEPs, and I understand that those students are not subject to the same punishments as the other students.
Okay, you've answered that. I mean, the question is whether the commission can second guess the school administration's procedures to handle inappropriate harassment when they see it, and they did see it. So, thank you.
Thank you.
Commissioner Brian.
No, yeah, it was
All
answered.
set?
Thank you.
Great.
Yeah.
Any additional questions for Ms. Duplessis? Seeing none, as I mentioned, you'll have a minute and a half when we come back to you. Attorney Trenholm, would you like to reserve any of your time?
2 minutes, please.
Sure, you can start anytime.
Hi, good morning. Thank you for your time. My name is Tom Trenholm, attorney with Drummond Woodson Counsel for respondent here, MSAD 52. And we're simply asking that the commission adopt the recommended finding of no reasonable grounds to believe that respondent discriminated against this student based on their race or sexual orientation and consequently dismiss the complaint. There have been no factual errors or omissions identified by complainant, nor have there been any issues raised with the legal standard. The issue with the video, just to address the question earlier, it's a hallway camera, and I do apologize, but we were ships passing in the night. I was able to get a still image of what one person could see by viewing that angle of the camera. It only shows the outside of this classroom in question, and it is a view along the wall, so you cannot see into. There's no angle to see into the classroom at all. But that, when we received complainant's response, people were on vacation, so we missed the 5 p.m. deadline. But there is also no audio recording from that video. As you can see in the record, the video was reviewed by the administration. And just to kind of take a step back, this incident that we're talking about back in June was initially investigated as a complaint of bullying against complainant's son, because he entered a classroom to initiate some kind of contact, or was with a classmate, and they were going in there to confront another student who was in that classroom. So as far as evidence of discrimination, this incident just from the get-go doesn't constitute that. And even if the staff member who was in that room, who all the witnesses say did not make physical contact with complainant's son, all of the students said that, and you have record evidence of what the staff member said when she was interviewed in that bullying complaint. The student complainant's son was not supposed to be in that classroom. And again, the school staff members had to do something to get him to leave. And all of the record evidence shows that that was appropriate, what the staff member did. And I think in Exhibit 9 refers to getting him to back out along with his classmate that he was in. The investigators' conclusion ultimately mirrors what the school administration found and what the outside investigator found. Although the Human Rights Commission investigator looks at things with a different standard, the 50-50 chance standard, our position is that there actually were not facts to establish harassment. There certainly were things that happened between complainant's son and other students. There was no evidence of a racial slur. You can see note 3 in the investigation report. That is essentially assumed to be true by the investigator. That was not found to be true by the school administration when they did their investigation, nor was it confirmed when Attorney Carey did his investigation. There's no question that a student said something to the effect of hating gay people. Again, that was found by all investigators to not have been directed at complainant's son. It was something he overheard. That doesn't excuse it away. But again, the question here is, did the school administration take prompt and appropriate remedial action when they learned of these things? And the evidence overwhelmingly shows that they did. That particular incident of overhearing that comment was not immediately reported. And once it was reported a week later, it was promptly investigated and other students involved were disciplined. There is evidence in the record of other students being disciplined. This is really a case of the school administrators being on the ball here. There's extensive documentation throughout Exhibit 9 about how their responses were prompt. There are numerous emails in Exhibit 9. You can see the timing of those administrators responding to Ms. Duplessis' concerns, sometimes within minutes of receiving that email, certainly within days. And the school's responses were appropriate, again, as reflected in the documentation in Exhibit 9. There were situations where the conduct went both ways. Students were separated, students were disciplined, supports were provided. Ms. Duplessis' son knew that he could always go. There were multiple staff members in that building that he could go to with his concerns. But understandably, being a high school student, you do want to try to deal with things yourself. And unfortunately, that didn't work out well in all cases. Are there any questions?
Questions for Attorney Trenholm? Seeing none, you'll have 4 minutes when we come back to you.
Thank you.
Ms. Duplessis, you have 1.5 minutes.
Okay, thank you. These are actually all the reasons that I find that you should find in my favor. Inconsistencies in the story of who entered the classroom first. Female student did or did not speak to my son. 2 witnesses not questioned as to pertinent physical contact with teacher. He did not initiate the contact. 2 female witnesses obviously answering promoted questions not shared in the report. Video, which would easily clear up the issue, never shared, viewed by respondent only. Remarks made to my son and the fact that they were not addressed adequately crippled his educational environment. The school decided not to address the bullying comments said to my son as said in his presence, but not directed at him. Thank you.
Thank you. Any additional questions for Ms. Duplessis? Seeing none. Attorney Trenholm, do you have anything to add?
I would only close with, to the concerns the complainant has raised about bias. That is why we have this process and the Human Rights Commission investigation. And that investigation, an unbiased outcome was a recommendation, no reasonable grounds, and that the complaint be dismissed. And that is what respondent is asking the commission to do today. Thank you.
Thank you. Any questions for Attorney Trenholm? Seeing none, thank you both. We will next hear from investigator Bob Bouchane.
Hi, good morning, everyone. Can you hear me okay?
Yes.
Great. Just to touch on a couple of points, the record reflects that here the respondent did act promptly and appropriately to all complaints of discrimination made by the complainant. Respondent conducted not only its own internal investigation, speaking to a large number of students, teachers, and staff before it came to the conclusion that all but one of complainant's claims simply could not be substantiated. The one claim that did result in 2 students being moved to another classroom, as well as unspecified discipline. So in this case, Ms. Duplessis or the complainant would have no idea what actual discipline was imposed. So it's difficult for them to be able to gauge whether it was appropriate or not. In this case, the respondent also took the additional step of retaining an outside law firm to conduct its own separate investigation of the same claims. And in this case, the outside investigation largely reached the same conclusions. As specifically noted in the report, while the commissioner is not bound by the findings of either investigation, it is certainly relevant to the question of whether or not their actions in response to the complaints were prompt and appropriate. And lastly, let me address the issue of the video recording that purportedly would have shown complainant's physical removal from the classroom after he admittedly entered it twice while it was in session to angrily confront another student. Even if the video did support complainant's claim of being physically removed from the classroom by the teacher, that would in no way mitigate or in any way excuse complainant's own admitted misconduct of entering a classroom and initiating a confrontation. At the very most, would simply establish that there may have been arguable additional misconduct by the teacher. That would in no way change the fact the complainant decided to enter a classroom twice while it was in session, admittedly to confront somebody who he believed had mouthed words towards him while he was walking by in the hallway. So again, even if the video was exactly as complainant as represented, all it simply would mean is that the teacher engaged in misconduct in addition to the complainant's own admitted misconduct.
Thank you, Bob. Any questions for the investigator? Commissioner Sanders.
Good morning. I'm curious about a piece of the report reflected in paragraph 3B. There's an incident described in this paragraph in which the complainant alleges that student 3 used a derogatory, discriminatory epithet towards him in the hallway, and then purported to what's described here as shoulder check him but missed. I'm curious about, though, it appears that neither the internal investigation that the school conducted nor the investigation that was conducted here substantiated that particular allegation. And I'm just curious about that. The last sentence of the paragraph reflects that at that time, student 3 had just returned from a suspension for exactly the same kind of conduct, right? So right. Allegedly, or in fact, right, it was determined that student 3 just returned from a suspension for shoulder checking, right? Precisely the same conduct, a female student, and calling her a vulgar name. And so I'm curious about, isn't that evidence, right, that in fact the same conduct occurred here? Just curious about how you arrived at the conclusion to potentially discount that factor.
Certainly. In this case, and during both investigations, it was found that there were no witnesses to the alleged incident. So again, I understand the possible inference that because this individual had done something similar a week or two prior, might indicate that he would be likely to conduct the same misconduct here. I think there's always possibility, and again, I don't know which investigation, what they relied on, but I think there's also the possibility that if complainant was familiar with the week prior incident, that he may have believed that that added credibility to his claim by claiming that the same thing occurred with him. Albeit again, in either case, there were absolutely no witnesses. So without any substantiating evidence, it was not unreasonable for the respondents to conclude that they couldn't find that any assault had occurred here either.
Thank you.
Any additional questions for the investigator? Sorry, you don't get to speak now.
Okay, sorry.
Okay, thank you, Bob. We've heard from the parties and the investigator, and at this time we're looking for a motion. There is one.
I
Proposed by-
okay, sorry. No, go. I move that the commission find that to adopt the investigator's recommendation as written, that there are no reasonable grounds to believe that MSAD 52 discriminated against Christine Duplessis on behalf of her minor child on the basis of sexual orientation and or race, and the complaint should be dismissed in keeping with 5 MRS section 4612 subsection 2.
We have a second. Been moved and seconded to find no reasonable grounds to believe discrimination occurred. Any discussion?
I mean, just a comment. First, Mrs. Duplessis, thank you for pursuing this claim. It's important that you did, to give this commission an opportunity to take a look at what happened. The conduct that's described here is deeply upsetting, right? Deeply troubling that your child would have to experience any of this conduct, right, in a public school setting. So I just want to acknowledge that it takes a lot of bravery and courage to come here. And I commend you for having done that for yourself, for your family, and certainly for your child. You know, the reason I moved as the way I did and will vote to find no reasonable grounds is that the law requires a finding that not necessarily that the conduct occurred, but that the school failed to respond immediately or timely, and then to implement remedial measures, you know, with the effect of ensuring that the discriminatory harassment did not continue. The evidence in this record certainly reflects that the school did that. And my hope is that your student has found, your child has found support, being able to recover from these experiences in their high school, high school experience. But I can't, again, on the basis of this record, can't make a finding that the school didn't comply with applicable state law. That said, though, you know, of course, I'm deeply troubled by the fact that any of this conduct, right, occurs in the K-12 setting. It's unacceptable, and you know, encourage MSAD 52 along with every other high school in the state of Maine to continue to work to make sure this conduct doesn't happen during the school day.
Yeah.
Go ahead.
Thank you. I totally agree. That's what I basically was going to say, what Commissioner Sanders said, but she said it much more eloquently than I could have. But I really appreciate the investigator's report. I feel that a few of the comments that Bob made, that the investigator made, solidified my vote, that it's just not, it's just, see how eloquent I can't even talk today. But I agree with Sam. Commissioner Douglas.
Yes, I agree with Commissioner Sanders as well. She said basically what I was going to say. No comments on her eloquence or lack of. I'm totally.
Well, we separated you.
Glad this is hilarious.
Look,
Yeah,
I appreciate you being here and advocating for your kid in the way that you're doing. Maybe you want to consider law school when this is all over and done with. But in the meantime, it's a question of the record. Nobody, I want you to understand, because I can see you're very disappointed to see how this is gonna go. Nobody is saying that these things didn't happen or that they're not egregious, right? Nobody is saying that. What we are constrained by is the record before us and the school's response, which is what's at issue here. Based on what we have in front of us, we can't make enough heads or tails to sort of overturn or question what the school did, whether or not it was appropriate, and so on and so forth. And I want to make sure that you understand that, if this behavior continues,
It hasn't.
assuming it's true, if this behavior continues, maybe the next time around we'll have better evidence and a better record. I heard you about the video. There's some conflicting evidence on that in terms of whether or not it would have actually been useful. I hear you about the witnesses that were not interviewed. I heard all of that. Okay. So, maybe there'll be better evidence next time. I mean, your kid's carrying around a phone, for example, video, picture's worth 1,000 words, video is worth 10,000 words. So, but anyway, I just wanted to say that I appreciate you being here today. Thank you.
Anything further?
Why couldn't you see the video?
Okay, it's been moved and seconded to find no reasonable grounds to believe that discrimination occurred. If you are in agreement, you will vote yes. Commissioner David.
yes,
Commissioner O'Brien.
Yes.
Commissioner Douglas.
Yes.
Commissioner Sanders.
Yes.
Okay, the findings are no reasonable grounds. Thank you all for participating. The commission will send a letter confirming the results of the hearing.
and the next case is Catherine Moulton versus Lakewood Hills, Lakewood Hills Federal Credit Union, I assume, E230292. The recommendation is for a finding of that we find that there is reasonable grounds, and therefore we'll hear from respondent first.
Wait a sec while we get in the parties.
Let me make sure. I think I have everyone.
Hi, good morning. This is Heather Hearn on behalf of the respondent. I apologize. I was having some trouble hearing you. Are you ready for me?
We are ready for you. Would you like to reserve any of your 10 minutes?
Yeah, 2 minutes sounds good.
Okay.
Thank you very much. So my name is Heather Hearn. I'm with the Coleman firm, and I'm appearing on behalf of respondent Lockwood Hills Federal LLC. First, thank you so much for your time. The investigator in this case identified 2 problems with respondent's conduct, and I want to talk about those 2 problems. First, the investigator took issue with respondent's May 2023 denial of complainant's request for accommodation. In the relevant part of the report, the investigator noted as follows. He said the following month, in May 2023, respondent summarily denied accommodations for situations that may happen in the future, advising complainant that she would have to make a new request for reasonable accommodation if she was asked to work on site in the future. This is not an accurate representation of the MHRA. The MHRA often allows for accommodation for disabilities that may have fluctuating needs, i.e. intermittent leave. And respectfully, this isn't an accurate characterization of the situation that was before the respondent in 2023 May. At that time, the complainant submitted a request that should a situation arise at some point in the future, acknowledging that no such situation was before them, but should such a situation arise requiring her to go in the office, she wanted respondent to prospectively accommodate her without knowing any of the specifics of this future hypothetical situation. Contrary to the investigator's findings, however, Respondent's denial of the requested accommodation in May 2023 had nothing to do with claimant's fluctuating needs. Her needs were already being fully accommodated because she was at that time 100% remote, and there was no project or need that required her to be in the office. Instead, respondent's denial was due to potential fluctuations of its own business needs. Respondent could not then, and really cannot now, know what projects or needs might arise in the future until those situations are before it. And at that time, as I said, there were no circumstances requiring claimant to go into the office, and therefore there was nothing to exempt her or accommodate her. Instead, claimant was essentially requesting what she already had. She was asking to be permitted to work remotely and not going to the office, and she was doing that. Respondent was already allowing that, but was simply refusing to issue a blanket exemption from all in-office work until a specific situation was before it. Moving on to the second point, the investigator also found that once respondent issued claimant an accommodation in August of 2023, respondent's requirement that claimant essentially renew that accommodation every 6 months was per se unlawful and, quote, effectively a denial of the accommodation, end quote. There's no support for this conclusion that a 6-month renewal requirement is per se unlawful, particularly under the circumstances before us here. Specifically, claimant's disability was not obvious, and she was entirely remote. Employers are required, as part of the interactive process, to regularly review the accommodation being provided and ensure it is necessary and workable for both parties. The law is very clear that this is a continuing obligation. Here we have zero face-to-face contact with claimant and a non-obvious disability. Respondent's request that she renew her accommodation request every 6 months. It's not only reasonable, it's the most responsible approach to complying with its obligation, a continuing obligation to accommodate her disability, to keep the lines of communication open, and to ensure that the accommodation being provided continued to be effective and workable. I think it's important to keep in mind here that claimant was at all times provided with the precise accommodation she requested. She was allowed to work entirely remotely. She was not required to go in the office, despite the fact, and I think this is key, that a provision in the collective bargaining agreement mandated that she be the first considered due to her low seniority when there weren't a sufficient number of volunteers. As the Seventh Circuit Court of Appeals has held, this is an area of the law where the ends, not the means, should be emphasized. And here the ends were achieved. Claimant was accommodated. She lost no time, she lost no pay, she suffered no adverse employment action. As such, the respondent requests that the commission find there are no reasonable grounds to believe that discrimination occurred here. And with that, I think I'm done. I probably reserved a little more than 2 minutes, but thank you.
5.5. Any questions for respondents, counsel? Seeing none, you'll have 5.5 minutes when we come back to you.
Thank you.
Ms. Moulton, you have 10 minutes. Would you like to reserve any of your time?
Can you hear me okay? I don't have a commanding voice, so awesome.
I can hear you. Everyone all set? Okay.
Awesome,
Yeah.
Thank you. I at least 2 minutes, but I might come in, I might have more than that at the end, but thank you.
Okay.
Great, thanks. So I appreciate the opportunity to present, as the respondent did not provide me with their response until a day after the deadline. Everything I'm going to share with the commission has already been provided to the investigator, so nothing I'm sharing with you today is new information. It is true that I was hired for a remote job with Lockwood Hills, meaning it was Lockwood Hills that established that my essential job functions can be done remotely. I was asked to come on site to help with a different department, which fell outside of my essential job functions. My management instructed me to apply for a reasonable accommodation to work remotely for my disability, even though I was already working from home. The respondent has said they did not approve my accommodation because it was unnecessary, but this creates a contradiction. It was the respondent who told me that the reasonable accommodation was necessary, and it is also the respondent saying that the accommodation was unnecessary. The reasonable accommodation that I requested had 2 parts. The first was for a request to work remotely, And the second was for a flexible schedule for the parts of my job that cannot be done from home, which are password resets every 6 months and badge renewals that occur every couple of years. The respondent is incorrect in saying that the accommodation was for a blanket exemption from ever coming on site. And at no point were any of my essential job functions requested to be removed or changed as part of the accommodation. The respondent has also cited that the collective bargaining agreement prevented them from approving my accommodation. This was never mentioned during my first denial. The reason I was given at the time was that the assistant operations manager did not want to approve the accommodation. In an email between my supervisor and human resources from May 18th, 2023, it says, "The assistant operations manager is the one that makes the decision on ADA accommodations. The assistant operations manager stated he did not want to approve, and we relayed this back to the Reed Group." It wasn't until October of 2023, after Lockwood Hills was made aware of my complaint with the Maine Human Rights Commission, that the respondent cited this as a reason for the denial. The union was then made aware of this claim. I'm now going to read their response, which comes from the union staff coordinator. "Hi, Kate. It looks like another episode of blame the union for our bad behavior, or we ignore the CBA most of the time, but are willing to weaponize it to suit our needs. 228 had a similar situation in the past and gave direction to management that the employee was to be exempted from the reverse seniority provision. There's a whole backstory, but they essentially had manufactured a need for on-site work, and everyone involved knew that the employee wouldn't be able to perform it, and what they were really doing was trying to push her to quit. I'm sure we could get with the executive board and request that the local provide a similar notification, either now or in the future, if this becomes relevant. The respondent is incorrect in saying that the accommodation would have been in violation of the collective bargaining agreement, as representatives from the union confirmed that it would not have been in violation. In their response, Lockwood Hills provided a quote saying, "In this area of the law, we are primarily concerned with the ends, not the means." I would argue that both the means and ends matter, especially when the means used by Lockwood Hills discourage employees with disabilities from accessing reasonable accommodations. For me, their means caused months of uncertainty and vulnerability, as well as exacerbated symptoms of anxiety. The respondent also says, however, Lockwood's later decision does not render this accommodation reasonable. It is my understanding that reasonable refers to undue hardship. This accommodation that the respondent is calling unreasonable is the exact accommodation the respondent told me to request, and this accommodation cost them nothing. When referring to the accommodation that was approved after Lockwood Hills learned about the complaint of discrimination, the respondent says, "Rather, employers should be and are free to provide more than the minimum, and Lockwood did, as noted above." In reality, the approved accommodation gave Lockwood Hills the ability to revoke it at any time, as well as essentially prohibited me from attending on-site events. They also disregarded my physician's recommendation for the accommodation to be reviewed every 12 months and required every 6 months instead. Lockwood Hills' process for requesting a reasonable accommodation costs time and money. For example, the last time my doctor filled out the required paperwork, it cost me $95, in addition to the time it took for my appointment. Also, my request for a flexible schedule to complete on-site tasks was never approved, and I have had to do password resets and badge renewals on my own time. This is not Lockwood Hills providing more than what was requested. It is less. Also in their response, Lockwood Hills says, "The disability in question is not immediately visible." This comment feels discriminatory in nature. I have been required to provide medical documentation and have been found to be a qualified individual with disabilities. I'm unsure why a differentiation is being made between visible and invisible disabilities in my case. To sum up, it was the respondent that established that my essential job functions can be done from home. It was the respondent that established that the accommodation was required. The accommodation did not change or remove any essential job functions, and the accommodation cost them nothing. The respondent denied my first request because the assistant operations manager didn't want to accommodate. The respondent wanted me to reapply for reasonable accommodation on a case-by-case basis. The union has stated that the accommodation would not be in violation of the collective bargaining agreement. The respondent partially approved my request and backdated it after learning about my complaint with the Maine Human Rights Commission. Again, the accommodation the respondent approved gave them the ability to revoke or modify it as they saw fit, prohibited me from attending on-site events, required a reevaluation every 6 months, and did not provide me with a flexible schedule for on-site tasks. I believe the investigator's original finding of discrimination on the basis of disability for a failure to provide reasonable accommodation is correct. Requesting a reasonable accommodation should not be stressful, expensive, or complicated, and denial should not be arbitrary. This whole process has left me feeling vulnerable and has been incredibly anxiety-inducing. I'm hopeful that the violation of my civil rights will ultimately be addressed, and I'm grateful for the Commission's time and attention to this matter. Thank you.
Thank you. Questions for Ms. Moulton? Being none, you will have 2 minutes and 50 seconds when we come back to you.
Thank you.
Attorney Hurd, you have 5.5 minutes.
Thank you very much. So I was taking some notes, a few points. Oh, one, I just want to address for Ms. Moulton. The issue of whether a disability is visible or not visible has nothing to do with whether, the company of the law views it as legitimate. It has to do with the interactive process and whether a company is immediately aware. So let me assure you that there is certainly no disrespect meant by that whatsoever. Turning to some of the points Ms. Moulton raised, so there is no contradiction here, and that is one of the points that she raised that I think it's worth diving into a little bit. First, and as the investigator noted, there were 3 requests, right? The findings were that there was a first request that was made on behalf of her or based on her daughter's disability. The respondent found that there was, no obligation here to accommodate it because she's failed to establish that it was based on her own disability. And that doesn't seem to be an issue for her. But that specific request was made at a time when there was a need for her to go on site. She then renewed the request, and by the time that request was processed, there was at that time no need for her to go on site. So when they said this is denied because you're already being accommodated, that was entirely accurate. The time that decision was made, there was nothing to exempt her from. That demand had already ceased, and she had, by the way, not been required to go. So while there was a discussion about we're concerned about what the CBA allows, we're concerned about violating the terms of the CBA, at the end of the day, she wasn't required to go. She was exempted. She was accommodated precisely in the manner that she asked for. The changing reasons was another point that Ms. Moulton mentioned, and what she's referring to there is non-attorneys talking about the reasons why they could not accommodate it. And let's be clear here, this was all hypothetical. Why can't you give me a blanket exemption? And the response is sort of a litany of these are the things that could have rise. Was it an exhaustive list? Certainly not. Was it termed in the way that I would present it as a lawyer? No. Were there terms like hardship or so forth thrown around? Yeah, I believe that came up. But again, these aren't lawyers talking. These are laymen talking. They're HR reps talking. We're not arguing here that there was an undue hardship in accommodating her. What we're saying is this blanket exemption based on speculative, yet to be unknown situations that may arise, that may require her to come in based on the demands of the federal government that we cannot control, that's not reasonable. At the end of the day, she was accommodated, though. We understood that she was unhappy with the resolution presented. So they said, look, what we'll do is we'll process this paperwork, but we will still necessarily need to evaluate each situation as it comes up and determine how we can accommodate it. I know Ms. Moulton is frustrated that the doctor recommended 1 year. The company did a 6-month evaluation. Again, in the case of a non-obvious disability, in the case of a fully remote employee, 6 months was entirely reasonable. And that's the standard. It's not, the doctor said this, therefore this is what has to happen. 6 months was reasonable under the circumstances presented. The flexible schedule, that's not addressed in the investigators finding that I've seen. And I have no indication that that was not accommodated to the extent that the company was allowed. But again, we work for the federal government. There are restrictions in place that we have to abide by. And what was done was reasonable under the circumstances. And let me just check, because I know I have a minute or two, and I just want to make sure I've covered everything, but I believe I have, if anyone has any questions.
Attorney Sanders, Commissioner Sanders, and Commissioner David.
Thank you. Both are correct.
I know.
Thank you, Attorney Crowe. I want to follow up on one specific remark you made a moment ago. You were characterizing the language that we find embedded in the email, right? So the emails from internal folks to the company, members of the management team, HR representatives, for example. You argue that we should excuse or discount sort of the language that those folks use, understanding, and I think you characterize these folks as lay people and not expert. I guess if I heard that correctly, I want to take you to task on that a little bit. And my first thought is, if the HR folks, right, embedded in the organization are not expert in the law related to disability accommodation, both under the Maine Human Rights Act and under the Americans with Disabilities Act, who is supposed to be expert in those matters? That's a core function of a competent HR team. And so I'm just, can you say more about that? I want to give you an opportunity to clarify.
And I'm not saying they're not, well, you know, expert's probably a strong word, but I think it was a misstatement, right? Undue hardship is a pertinent analysis under the Maine Human Rights Act, under the ADA. Whether an accommodation is reasonable is sort of that initial burden. And so they started talking about hardships, and then they're throwing undue hardship. And that was, it was an unfortunate choice of words there. We're not arguing here that the denial of the accommodation in January of 2023, or I guess it was in May of 2023, was an undue hardship. What we're saying is the request under the circumstances where there was no situation before it to exempt her from, that wasn't reasonable. And that's that initial threshold. Whether an undue hardship could present itself at the point, at some point when there was a specific situation, I think that's more what this person was speaking to when we sort of conflated these issues. And because again, they're dealing with something that's speculative and not before it. Does that answer your question? As I hit things and throw things around? Apologies if you heard that.
Thank you very much. I appreciate it.
Yeah.
Any additional questions? Seeing none, thank you. Oh.
Yeah, no,
Commissioner Davis,
please.
go ahead.
I'm still confused. On the one hand, you're saying that the company could still evaluate on a case-by-case basis whether they were going to agree that the accommodation excused her from appearing. How does that translate into saying having to refile every 6 months is reasonable? I guess that's two questions. Can the company say they grant an accommodation that she can work from home, and then a situation comes up that, according to you, is a federal requirement and some reason that she has to come in the office? Can they say, "I'm sorry, we can't honor our own accommodation at that point. You have to come in"?
So she was two parts. And tell me if I'm not understanding your question, right? She's already working from home. There is presently no need for her to go into the office at all. But these situations arise from time to time where she might need to go in. Sometimes it's a password reset. Sometimes it's secure documents. Sometimes it's something else. And what they're saying is, let's process the paperwork. Let's get everything set up so you're ready. But please understand that we can't foresee every situation that could come up. So when such a situation comes up, we are going to need to just evaluate it based on the facts presented, because we're not omniscient. We don't know what we don't know. Does that answer your question, or is there another part there that I'm missing?
No, is that granting the accommodation?
I believe it is granting the accommodation based on the facts that she had at that time. She's saying, I can't go into the office, and we're saying we don't need you to right now.
But you're saying it with your fingers crossed that if a situation comes up, we'll take it back and you will have to come.
No, what they're saying is if a situation comes up, we are going to need to evaluate that. A blanket accommodation up to, not knowing what, this is not a standard part or I guess a foreseeable. It is essential, but it's not a regular anticipated part of the job, if that makes sense. And I understand that doesn't sort of sound correct, and I'm struggling for the words here, but they don't know what situation will come up that will require her to go in the office at some point in time. So how can they say, yes, absolutely, no matter what happens, we can 100% exempt you from that? That's not a reasonable approach to operating a business. It's not a reasonable approach to the law.
Okay.
And any further questions for Attorney Hearn? Seeing none, thank you. Ms. Moulton, I think I said you had 2 minutes and 50 seconds left, so.
Hey, thank you so much. I just want to reiterate, and this is all going to be off the top of my head, so I apologize, it's not going to be organized. The request was never for a blanket exemption. We understood that, again, with the password resets and the bad renewals, that there are parts of my job that call me on site, and we had asked for a flexible schedule for that. And that would have been in the original emails that the investigator would have gotten. So again, that's not like, new information outside of the report. And my job, the job I was hired for, there is no on-site work beyond the password resets and the badge renewals. So accommodating into the future there never should have been a hypothetical situation to come up. And even if, the one that triggered this whole situation was another department. And with the reverse seniority, is how I was called in, but then the union said I absolutely would have been exempted. So again, that hypothetical situation was already kind of addressed. And again, it was management that told me to apply for a reasonable accommodation in all 3 instances. I have not spontaneously applied for a reasonable accommodation without being told to by my management first. Yeah, so I apologize. I will end it there just because my brain has completely shut off. So thank you.
Thank you. Any questions for Ms. Moulton? Dina, thank you very much.
Thank you.
Have heard from the parties. We'll now hear from investigator Alex Brinkley.
Hi, everyone. My name's Alex Brindley. I was the investigator assigned to this case. I think the parties accurately reflected or represented what they reflected to me during the investigation. I don't really have anything that I would like to add further, but I am open to questions as always.
Commissioner Sanders.
Thank you. Just out of more of a passing curiosity, if it's in the record, this notion, right, of the collective bargaining agreement not permitting modification to the seniority, sort of structure for recall into the office. I think I heard the complainant say that the union specifically had articulated an amendment to the CBA, which allowed for exemptions to the seniority process in the event of disability accommodation. Again, if it's in the record, is that a fair characterization?
Not to my knowledge. We also don't have purview over CBAs.
Sure, just curious. Yeah. I mean, just curious about that because it is, though we don't have jurisdiction to opine on a CBA, it is of, potentially a fact that's relevant in the accommodation analysis. Yeah, okay.
Other questions for Investigator Bridley? Seeing none, thanks, Al. Thank you. Okay, we've heard from the parties and the investigator. At this point, we're looking for motion. There's one.
I move to accept the recommendation of the investigator as written in the report. One, that there are reasonable grounds to believe that Lockwood Hills Federal LLC discriminated against Catherine Moulton on the basis of disability, and conciliation should be attempted in accordance with 5 MRS section 4612 subsection 3.
We have a second.
Second.
Sorry, you have to do both. Okay, it's been moved and seconded to find reasonable grounds to believe that discrimination occurred. Any discussion?
Sure, so even if we're persuaded that the accommodation reflected under paragraph 6B, that's the sort of dispute about needed to come into work. The employer articulates that it was no longer a request, and so therefore the accommodation was denied, right? Even if we were persuaded by the respondent's argument in that regard, we still have the issue of sort of the rote and reflexive, right? You've got to recertify or re-articulate the need for accommodation every 3 to 6 months. That, sort of the way it's presented is inconsistent, right, with the expectations under the law. Really what should be happening, right, is the employer have a discussion with the employee to the extent that there are questions about the efficacy, right, of an accommodation that's been put in place. To simply require the employee every 3 months to go back out, for example, to their provider, physician, whomever, and recertify is a burden that the law doesn't support. Not to mention sort of the related considerations of cost, right? And consumption and sort of, again, not within our purview here, but to the extent you're driving your employee back to their provider, there's significant burdens, real world, real life, real people burdens associated with doing that when it's not necessary, right? Because the employer hasn't checked in first to say, how is this working? And may not even have concerns about the efficacy of the accommodation. So that's how I'm approaching this. Again, even if I'm persuaded by respondents' counsel about the second request, it's this sort of reflexive, ongoing requirement to recertify that's problematic and again inconsistent.
Any additional discussion? Seeing none, it's been moved and seconded that we find reasonable grounds to believe that respondent discriminated against complainant on the basis of disability. If you are in agreement, vote yes. Commissioner David.
Yes.
Commissioner O'Brien.
Yes.
Commissioner Douglas.
Yes.
And Commissioner Sanders.
Yes.
Findings are reasonable ground. Thank you both for participating, and you will receive a letter confirming the results and outlining next steps.
Thank you.
Next case is E230340 Catherine McSweeney versus Drummond Woodsum. And the recommendation is for a finding of no reasonable grounds, and therefore we would hear from complainant.
Everybody,
No.
yeah, we're waiting for response.
Okay, hold on.
Sure.
Hey, I'm here.
Is Melissa also here or just you, Peter?
It's just me.
Okay, thanks. Then that's everyone.
Okay, Ms. McSweeney, you have 10 minutes. Would you like to reserve any of it? You're muted.
Sorry, I don't believe so.
Okay, then you have 10 minutes and you can go ahead.
Good morning, commission members. My full name is Catherine McSweeney, but I usually go by Kitty. Before we begin, I first want to thank you all for being here today and agreeing to hear my case and for rescheduling this as I was really sick last month. Thank you so much. I'd like to ask some initial procedural questions before my presentation, as I want to make sure we're all working with the same information. Has the commission reviewed and is the commission in possession of a copy of the initial complaint, the respondent answers to the complaint, and the reply to the respondent's answers? Have any of these materials been redacted? If any of the materials have been redacted, I would like to state for the record that I have neither received notice of any such redactions nor have I had the opportunity to reject. Has the commission reviewed and is the commission in possession of a copy of the investigator's report dated June 12th, 2025? Has any of that material been redacted? If any material has been redacted, I would like to state for the record that I have neither received notice of any such redactions nor have had the opportunity to object. Has the commission reviewed a copy of my response to the investigator's report dated July 3rd, 2025, including the cover letter? Has any of the material been redacted? Has the investigator had a chance to review this response? Has the commission counsel reviewed the response? I would like to note, I would like to say for the record that I have not received any notice of any such redactions, nor have I ever had the opportunity to object to any redactions if that happened with any of the information in this case. The investigator's report dated June 12th, 2025 and submitted by Angela Morris contains numerous relevant factual errors, as well as omitting many relevant facts that were submitted during the investigation. Not only is this report factually inaccurate and false, it also makes assumptions that are incorrect and inappropriate, which leads to an incorrect legal analysis. And it appears that this report is based solely on acceptance of the respondent's response as unvarnished truth and does not take into account the numerous inaccuracies and errors that Drummond Woodsum admitted to during the investigation, as I have already described in great detail in my complaint and response. I find it discouraging that this report has misconstrued and not reflected most of the relevant information I included that clearly shows the mistreatment and discrimination that occurred during my employment at Drummond Woodsum. Like, just to summarize quickly, I said I was pregnant in August 2022, and immediately my hostile work environment became very clear. People stopped giving me work. I was meeting with HR. And I wrote an email on the 20th of October 2022. Stating these problems and saying I would like a performance review because I take a medication that I need in order to do my job well, but I was never given an opportunity to do that. Instead, on November 4th, 2022, and the respondent held a meeting without me. And 2 weeks after I wrote the email to HR expressing my concerns about being discriminated against, as it's seen in my Exhibit A, which is the response to the respondent's response, and with the coworker that had been harassing me, they had a meeting with the person that I was saying was harassing me, which went against their own handbook. And which you can see, just to discuss my job performance. And not only did they have this meeting, but the meeting has redacted notes from what Drummond Woodsum submitted. There's redacted notes in here, and I don't know why, if the meeting was just about me, there are redacted notes. What was clear is that during this meeting, none of my concerns about hostile behavior and harassment that I had previously said to HR were discussed. I was never aware of this meeting, and I was very overwhelmed and stressed out about the toxic work environment I was in. And so, then it was all just about my issues with Colleen Tucker, which again are in all of the information that I submitted. But I'm wondering if if everybody has all the information, because, in the investigator's report, it said the dates were wrong. It also said that they moved my desk, that Drummond Woodsum moved my desk. And then I'm looking at Drummond Woodsum's response here, and they never moved my desk. In fact, it says that in Drummond Woodsum's response in December 2022, in order to address complainants' concerns, it was determined that complainant's workstation would be moved, so she no longer sat next to Colleen Tucker. And so I was never informed of that. That never happened. But in the investigator's report, it says that my desk was moved. So this is why I'm very concerned about everybody having the right amount of information. And then in response to the narrative and events of this matter, I responded that the respondent did not address any of my concerns. I never got the performance review I asked for. There was a secret meeting in retaliation to my email from October 20th with the redacted notes. And that was the only, but I was never told anything about that. I never got to tell anybody about my medication. I never had any opportunity to do this, which again, went against Drummond Woodson's handbook, which they didn't submit to the commission properly. They submitted something about transgender bathrooms. I, in my response to the respondent's response, submitted the proper procedures from the Drummond Woodson handbook that was originally requested. So they didn't even submit the proper evidence here. And moving forward, the hostile work environment, the response to my email, initially when after the April 26th phone call with Jess Garrettson, which they replaced me at my job, which I submitted evidence to prove. They hired Carrie Hirehort in April 2023, and then they called me immediately after to get rid of me because they had my replacement, and they started advertising for my job right after I emailed Jess Garrettson that I'd had my son. And so,
listen, sweetie, I'm gonna just ask you to pause for a second. You can't use third-party names, so if you could stop referring to folks by their actual names and just use a pseudonym, that would be great.
I'm sorry. HR. So after HR fired me over the phone, and then there's just so many questions here. And so then they immediately offered me a severance agreement, which then in the investigator's report, the severance agreement makes it look like I asked for a severance agreement, like I was just doing this for money. No, I didn't ask for a severance agreement. I didn't accept the severance agreement. I wasn't doing this for money. I didn't want them to say that I abandoned my job. I didn't abandon my job. I was owed unemployment because the first thing Jess Garrettson said to me was that but they didn't have any more title work for me. I mean, so I don't know why. I think that my really difficult part about this is I just don't know why the investigator's report didn't say any of this, and why and then the facts weren't honest to the evidence submitted by the respondent. So I would just, and I did not resign or abandon my job at Drummond Woodson or at the firm, and despite the firm's narrative to the contrary. So for the law, I would like now to read a portion of the law regarding discrimination in employment against pregnant persons and highlight a few points. Unlawful, this is Title 5, 4572, unlawful employment discrimination. Unlawful employment discrimination, it is the unlawful employment discrimination violation of the act except when based on a bona fide occupational qualification. For any employer to discharge an employee or discriminate with respect to hire, tenure, promotion, transfer, compensation, terms, conditions, or privileges of employment, or any other matter directly or indirectly related to employment. So for pregnant persons, this is 4572A, is unlawful. It is unlawful employment discrimination in violation of this act, except where based on bona fide occupational qualification for the employer, employment agency, or labor organization to treat a pregnant person who is able to work in a different manner from other persons who are able to work, which they did. They stopped giving me work, and they had secret meetings about me, and then they replaced me at my job. And then, pregnant persons who are not able to work, it is unlawful employment discrimination in violation of this act, except where based on bona fide occupational qualification for an employer, employment agency, or labor organization to treat a pregnant person who is not able to work because of a disability or illness resulting from pregnancy. And my disability was that I couldn't take my medication, but I never got an opportunity to tell them that. So, it's really, just, I was very surprised at the investigator's report that it didn't mention any of my response to the respondent's response, which proves all of this, everything that I'm saying. So I would like to respectfully ask the commission to ask yourselves the following questions. Why didn't Drummond Woodson attempt to resolve my allegations of harassment discrimination? Why didn't they do anything with me to attempt to resolve that? Instead, they had a secret meeting behind my back and with redacted notes that I think probably say that they were trying to get rid of me, because why else would they redact those notes? Why didn't Drummond Woodson ever conduct a performance review when I asked for it numerous occasions? Why was I treated differently once becoming pregnant? Why was I never given the chance to explain that any decrease in performance was due to medical reasons? Why didn't this investigation ever compel the HR manager at the time to testify, which is also another interesting point, because the HR manager at the time, she no longer worked at the firm starting on the 28th of June, 2024, 8 days after the director, Kit Thompson-Crossman, emailed myself and attorney Huey, and attorney Huey never responded, saying that there was going to be an investigation. 8 days later, the HR manager that I'm complaining about here no longer had a job at the firm and did not get another job according to her LinkedIn profile until August. And then last, during the January Issues and Resolution Conference, when it was asked that maybe this woman attend for the HR manager, Attorney Huey said that she didn't want to talk to the commission. But how do we know that? I never saw an email. There was no evidence to support that Attorney Huey actually reached out to her or anything like that. So my understanding is probably that she's on some maybe agreement with the firm that she can't talk. But I think that the commission here has power to override that. And so that's why I'm wondering why, this HR manager was never compelled to testify in this case, because she definitely lied under oath to unemployment. But when she did that, she was still employed at the firm. So I think it would be an interesting thing to talk to her now. And why has no one questioned why the firm's responses were intentionally omitted and redacted from that meeting? Why are those notes? And why does the employer get to decide if the employee was fired or not? Under what facts did the investigator choose to believe the employer over the employee? So my conclusion is that, Drummond Woodsum is guilty of discrimination. The truth is that I faced incredible hostility and unwarranted abuse from a supervisor during my employment. The firm did nothing to acknowledge or resolve the situation. They did not move my desk, and they never said they did. So I don't know why the report says that. So they exacted an enormous amount of pressure on me to quit and resign, specifically because they were afraid I would sue them for discrimination. I did not resign, nor did I abandon my job. This is an example of unchecked power. Once I refused to play their game, they brought all their full power to the firm to make sure I could not collect unemployment or get another job with another firm. This was discriminatory and retaliatory. It was petty, mean, and wrong. So it is my sincerest hope that the commission is able to perform the duty and protect and defend an unrepresented mother and citizen in the state of Maine and its unchecked and unlawful abuse of power. So I call upon the commission to do as it stated.
That's your time.
Okay.
Thank you. Any commissioner questions for Ms. McSweeney? Commissioner O'Brien.
Thank you. Good morning. Can you address the email that you sent to HR that where are we? That you're saying I cannot return to DW in any capacity.
When was this?
Hold on.
No, that was a text message that I sent to a coworker that helped me get the job. That was not HR. That was not a supervisor. That was not anybody that I worked under. That was a friend, and I felt badly because they just fired me, and I didn't understand why. And I even said it's been determined I was bad at my job. I guess because they didn't actually give me any evidence as to how I was bad at my job or a performance review. So that wasn't.
Hold on. That's there are two. You messaged another paralegal. I've decided I'm not returning to Drummond Woodsum, and then also you said to a colleague or whatever you just said, but according to this, you sent an email to HR saying that you I cannot return to work.
I did not send that email.
True?
That's not true. No. I did not send an email to HR saying I could not return to work at any point. No, that is not true. I sent after after HR fired me over the phone, I sent a text message to the woman, a coworker that helped me get the job. I felt badly about it, but I was in shock. I didn't understand what was going on. It was not a resignation, and I never resigned. I never resigned from this job.
Okay.
This is all after the discrimination happened too. I mean, this is part of the discrimination, but this is not actually the crux of the discrimination. This is afterwards, which is why I think there should be a new investigation here.
Thank you.
Thank you. Any further questions for Ms. McSweeney? Seeing none. Attorney Felton, you have 10 minutes.
Thank you. Good morning. This is Peter Felmy. Hopefully you can hear me okay. I'm here representing the respondents in this matter. From the respondent's perspective, the record is quite clear that about the reason for complainant separation from employment. In no uncertain terms, she was informed that she was welcome back, that she would continue with the title work that she wanted to have, that her desk would be moved, her supervision would be adjusted, and she'd be supervised by different attorneys. The attorneys are named in the emails between the complainant and respondent. representatives, and they are included in the record. Complainant elected not to return. The text message that was just referenced is evidence of that. Further evidence of that is she didn't show up after June 26th, and the email from HR to complainant indicated that we expect to see you at 9 o'clock in the morning tomorrow. She didn't arrive. And the investigator in this case carefully assessed the record, correctly concluded that there was no adverse action. There's no adjustment to complainant's pay. There was no denial of leave. In fact, she was given 12 weeks of paid parental leave and 12 weeks of unpaid parental leave at her request. She was not disciplined. There were performance issues, and they were communicated to her, and the plan was to continue to work with her about these performance issues and support her through them. Had she returned, again, she elected not to. There's been some reference in the materials to supposed lack of work, and that was the reason why she was, in her view, fired. That theory is supported by no evidence at all, and it's contradicted by actual hard evidence. Exhibit 8, the June 7 email, the work is there for her. June 15, that same email. That email makes very clear that the work is available to her. The June 22nd email explicitly states, when you come in on Monday, we'll meet setting up your work. Title work, the work that you requested, will be funneled through a different attorney. You'll continue to support the real estate team, but also others in the land use and municipal group, and you'll be supervised by a different individual. The June 26th email, the one I referenced earlier, indicates that look, you've asked for a separation agreement. The evidence that you can see in Exhibit 8 shows the back and forth about the terms and conditions of the severance agreement. Ultimately, it got to a point where she needed to decide whether she wanted to sign off on a severance agreement or whether and a mutual separation, or whether she wanted to return to work. That choice was presented to her on June 26th, and on the next morning when she did not show up at 9 o'clock in the morning, it was clear to the respondent what choice she herself had made. For all these reasons, the respondent respectfully asks that you accept the considered, thoughtful investigation report by Investigator Morse, and that you issue a no reasonable grounds finding. Thank you.
Thank you. Commissioner, questions for Attorney Firmly? Commissioner Douglas.
Yes, good morning. Just briefly, I'm just looking at the investigator's findings here and considering what complainant said. The investigator found that in December 2022, respondent addressed complainant's concerns by moving complainant's workstation away from supervisor and assigning her supervisory duties to another employee. The complainant says that that did not happen. I just wanted to get your take on that.
Well, I believe I'm looking at the submission that the respondent made on November 13, 23. On page 3 of that, the concern was looked into in December of 22. Then we have a holiday, and then she goes out on maternity leave at the very start of the next year. So there was 24 weeks of leave where she wasn't there for the respondent to implement that decision. And when she decided on her own not to return, she walked away from that opportunity to have that workspace addressed. So I think it's a timing issue.
I see. Okay. So was these decisions to move the workstation and assign the supervisory duties to other people, were those communicated to a complainant before she went out on maternity leave?
I don't know the answer to that question.
Okay.
But certainly while she was out on leave and before she was to return, it was mentioned on multiple occasions, and the emails, capture each one of those concerns.
All right, so just so I'm clear, right? She sends an email in October reporting the shift in treatment by her coworkers, et cetera, right? And she complains about one of her supervisors freezing her out and trying to get her into trouble. And then in December, some decision is made to move her workstation and change her supervisor, right? Which may or may not have been communicated to her before she goes out on maternity leave, but definitely was communicated to her while she was out of maternity leave, right? That's your position?
Yeah.
Okay, all right, thank you.
Any additional questions? Seeing none, we've heard from both parties. We'll now hear from investigator Angela Morse.
Hello, my name is Angela Morse. I'm the investigator that was assigned to this case. I don't have anything specifically to add, but I'm certainly willing to answer any questions. I think the emails and the messages from April to June of 2023 are pretty telling that there was no job termination, there was no demotion, and I simply don't see any evidence that there was any severe and pervasive abusive conduct that would equal a hostile work environment.
Thank you. Any questions for the investigator?
Am I allowed to ask a question?
You're not. Seeing none. Thank you, Angela. We've heard from the parties and the investigator. We're now looking for a motion. There is one proposed finding.
I'll make a motion that we find that there are no reasonable grounds to believe that respondent unlawfully discriminated against complainant in violation of the act, and this claim should be dismissed.
Please reopen this investigation. Please reopen this investigation.
Second.
That is not the motion.
I second that.
Thank you, Commissioner O'Brien. It's been moved and seconded to find no reasonable grounds to believe that respondent discriminated against complainant. If you agree, you will vote yes. Commissioner David.
Yes. Yes.
Commissioner O'Brien.
Yes.
Commissioner Douglas.
Yes.
Commissioner Sands.
Yes.
Finding is no reasonable grounds. Thank you for participating. You'll receive a letter confirming the outcome of the hearing. Ed, 5 minutes.
Sure. 5 minutes. It's 11:20, 11:25. We will resume. I'm sorry, 10:20, 10:20, 10:25 for you people. All set, Barbara? Ready to go? The meeting room says it's on mute.
Oh.
Yep, they're finishing up lunch. Finishing up lunch orders.
Green pepper and
Thank you.
We are unmuted.
Ready? We're all sad.
Okay, thank you. Next case for hearing is E230377, Brenda Tomei versus Hershey Ice Cream. The recommendation by the investigator is that the commission find that there are no reasonable grounds, and therefore we would hear from complainant first.
That's right.
Good morning.
You have 10 minutes. Would you like to reserve any of your time?
I guess so. Okay. 2 minutes?
Sure.
Okay.
You can go ahead.
Okay. Good morning. I appreciate your time. I just have two portions of the investigator's report that I do not agree with that I'd like to mention. First of all, it says there's a completion of medical exam and drug test that was a condition of employment in this position. This was not and is not true in the branch that I'm located at. I was never offered the opportunity to take a medical exam or drug test, and the person that has replaced me did not have a medical exam or a drug test. And the second part is the compliant had not attempted to obtain medical clearance or drug test, although respondent provided that it was told to her that she could work up as a backup loader once she had done so. To this day, I have never been offered the opportunity to take the medical clearance or exam for a drug test. My former boss can attest to this, to the facts above. He can also, and also the office manager who was responsible for setting up the drug testing and medical exams could also attest to the above statement. That's it.
Well, you have plenty of time left when we get back to you. Are there any questions for Ms. Tomas?
just that, good morning.
Good morning.
Still morning, yeah.
Yep.
I just would like to clarify what you just said. That it was never, are you saying that this, it was never, not that it wasn't offered, but that it was told to you and that you needed it and had not known that you needed it before? And you say not offered to you, so I guess I'm a little confused. Are they supposed to go to you and say, fill out this form? Or did you, are you saying you had no knowledge of it?
I had no knowledge of it.
Okay, thank you.
There's still questions. Yes, Commissioner David.
Yeah. Yes, are you still employed by the respondent?
Yes, I am.
Okay. I'm struck by the fact that your presentation doesn't tell us anything about age or sex as being your claim of being discriminated on that basis. You have this disagreement about the drug test, but what's the problem?
I just assumed that all that information was already, that everyone already had that knowledge.
That's the claim.
What the commissioners have, whatever you submitted in disagreement with the report. report.
Oh, so that's the only information. Oh, okay, well,
And the investigator's report.
okay. So in other words, I think that maybe I need to start from the beginning of what I submitted. Is that correct?
You can present whatever you want, but
Okay.
all they have read is the investigator's report and your.
Okay. Okay. I began working in on September of 2022, and about 6 months after my employment, I was asked to start loading in the freezer. I was also recognized in the July newsletter for my outstanding performance for these additional responsibilities. And then on August 15th, 2023, I attended a sales milestone celebration dinner, and it was the entire office and two senior supervisors. And the next few days, I think it was that was on August 15th. On August 21st, I was told by my supervisor that I was no longer to perform the duties in the freezer. And I asked him why, and he said he wasn't sure, and he thought it might have to do with safety concern. But he also told me that one of the supervisors had told him that he needed to get the ladies out of the freezer. So I just felt that either, because it was the first time they met me, I felt like it was either my age, my gender, or my physical appearance as to why I was asked to not do that job anymore. I was doing a good job, so that's why I think that there was some discrimination there.
Okay.
Any additional questions? Go ahead.
Yeah, good morning.
Good morning.
So I hear what you're saying. I hear where you're going with all this. The investigator's report that we have says that, you didn't have the required medical exam and drug test. And that's why you couldn't do that job. I mean, is it not true that you did not have these things?
That is true that I did not have those, but I was not required to do that, to perform the duties.
I understand you were doing this before without having the drug test and the exam.
Yep.
I understand that, but I think that was justification for not moving forward with a more formal arrangement, is what I'm saying.
Yes. Yes, but I would like to state that the people that are doing the job right now have not had a physical or a drug test either. in my branch location.
Understood. All right, thank you.
Thanks.
Additional questions? Seeing none, you'll have some unknown, hang on. You'll have 7 minutes when we come back to you.
Okay.
Okay, attorney, is it Snavely?
Yes,
Great. You also have 10 minutes. Would you like to reserve any time?
sure. I would like to reserve 2 minutes. Thank you.
Okay, you can go ahead.
Good morning. My name is Lindsay Snavely. I represent the respondent in this matter, Hershey Creamery Company. Thank you for your time today. I will try not to belabor everything that has been raised as part of the position statement and in response in the investigator's report. I'll just hit on a few points. Ms. Tomaz was hired as a customer service representative in 2022. She was, I believe, 57 years old at that time. As a customer service representative, she was not required to take a medical certification. That is clearly listed as a not requirement on the job description. It is not listed there as a requirement. In or about August 2023, a new supervisor who was assigned to the region did an assessment of the company's Augusta, Maine branch location in preparation for the retirement of the then branch manager. As part of that assessment, it was determined that Ms. Tomaz and another female customer service representative were performing the job as a branch loader / utility position. In short, the branch loader utility position is to load and unload delivery trucks with respect to ice cream in the freezers. The individual who conducted the assessment determined that because Ms. Tomaz and this other individual had not received the medical certification that was required for the branch loader / utility position, as listed on that job description, that they could not continue to perform that position as backup employees. They did indicate, however, that if she wanted to perform the functions of that position moving forward, she would need to pass a medical examination and a drug test to perform. To date, she has not done that. She has not taken a drug test. She has not applied to be a branch loader utility position, and no one at the company has stopped her from doing that. Since that time, she has remained in the customer service representative position. She has worked more hours in that position than the branch/loader utility backup. She has received a pay raise. To that end, there has been no adverse action taken against Ms. Tomaz in any capacity. So for these reasons, we would respectfully request that the commission upholds the findings of no reasonable cause for age or sex discrimination. Hershey Creamery has other women performing the branch loader utility position at other branches. They also have individuals who are over 40 who are performing those positions. So that is not the reason that Ms. Tomaz was taken out of that role in a backup capacity. To the extent that Ms. Tomaz said another individual made a comment about getting the quote unquote ladies out of the freezer as part of this investigation into responding to Ms. Tomaz's complaint. We reviewed that, and that person categorically denies that he ever made a statement. And it would be nonsensical for him to make such a statement, given the fact that Hershey Creamery has other women and individuals over the age of 40 working in that same position in the branch loader/utility position. So again, we respectfully request that the decision be upheld. I'm happy to answer any questions you may have. Thank you.
Thank you. Commissioner, questions for Attorney Snavely? Yes, Commissioner O'Brien.
Thank you. I just want to clarify something in my mind. She was hired as a part-time customer service rep, but then she was doing, I am reading, I believe that she was also doing this when it was short-staffed. So it was an addition to her job. Okay, so essentially she still was a customer service rep?
Yes.
Or
yes, she was still a customer service rep. She was performing the branch loader utility position as a backup, along with another female customer service rep and the then branch manager, because the branch was so short-staffed at that time.
Okay, thank you for now.
Commissioner Douglas.
Yeah, good morning. Just for complainant's benefit. So my understanding of your client's position is that, I mean, she's still working in her original job, right? Her real job, as we know. My understanding is that if she wanted to take this medical exam, right, and this, whatever else needs to be done, and work and apply for a job, loading the freezer, whatever, that you folks would not have a problem with that.
No, Hershey Creamery has never had a problem if she would want to take that exam. Now, to the extent that there is a quote unquote open position at this time, I'm not sure at this time. But no one is stopping her from taking that and or applying for any open positions for which she would be qualified.
Thank you.
Additional questions? Seeing none, you will have 6 minutes and 20 seconds left when we come back to you. Ms. Tomaz, you have 7 minutes.
Okay, so I guess I just want to say that I was never offered to do that, for that. I was never offered to apply for that position, and the position was posted. It was posted for someone else, for another. It was posted without my knowledge, and I would have gladly taken a drug test and had a physical if somebody had asked me to, but nobody had asked me to. And the people that are doing this job right now at this branch, they haven't had to have a drug test or a physical. So I'm not quite sure why I would have had to if the other people don't need to. I mean, I do know that if you drive a truck that you need a drug test and a physical, but the freezer people that are working there right now aren't required. So I'm not, so my question, I guess I'm questioning why I'm required to do it, which I would have no problem doing if I had to.
Thank you.
It,
Okay.
it begs the question, why don't you do it?
Well, because right now there is not an open position.
Well, that was actually my next question. The people that are hired, they have not been short-staffed because they've hired people that are doing the job, right?
Right now, we're not short-staffed, yes. Which it still brings me, I still feel like, I still believe that it was something to do with my appearance or something when he met me, because I received praise in the newsletter for doing such a great job filling in for this. And then, I mean, these people met me and all of a sudden I can't do the job. So that brings me to the conclusion that I was discriminated against for some reason.
Do you know the sex of the people that are hired
Yes.
for the job?
Mm-hmm.
What is it?
They're all men.
Hmm.
So
That's all. Thank you.
Any additional questions? Seeing none, thank you. Attorney Snavely, you have 6 minutes and 20 seconds.
Well, I'll just respond very briefly. I think Ms. Tomaz admitted that the position was posted. She had every right to apply for the position. She did not do so. She has every right to get a medical certification. She has not done so. The position, I can after the assessment of the branch back in 2023, the location decided to hire an operations manager, which was completely different than a branch utility slash loader. So I just want to make that clear that there was not a male hired to take over her quote unquote backup position as branch loader slash utility. As part of this investigation, it was also determined to the extent that there were not drug tests done on people in the past. That was because certain individuals, including the HR in that location, are not following HCC requirement, Hershey Creamery requirements. It's very clear that they need that as part of being qualified for the branch loader position. And again, I'll just say Ms. Tomaz has every right to apply for that if another position becomes open. So thank you.
Yeah, I don't know why I bothered to time either one of you. Questions from the commissioners for Attorney Snavely? Seeing none. Thank you both. We've heard from the parties. We will now hear from Investigator Morse.
Hello, my name is Angela Morse. I'm the investigator that was assigned to this case. I don't think I have anything to add, but I'm certainly willing to answer any questions.
Any questions for Angela? Seeing none, thank you. All right, we've heard from the parties. We've heard from the investigator. We are looking for a motion. There is one proposed finding.
I move that we accept the investigator's recommendation as reflected in the report. One, that there are no reasonable grounds to believe that Hershey Creamery Company discriminated against Brenda Tomaz on the basis of age and or sex, and the complaint should be dismissed in accordance with 5 MRS section 4612 subsection 2.
Second.
Thank you. It's been moved and seconded to find no reasonable grounds. If you are in agreement, you will vote yes. Ardalia.
No discussion.
Oh, Ashley. Any discussion? Oh, look.
Yes, please.
You go get them.
Yeah, thank you. Try to cut me off. I just want to, well, to everyone, it's a wonderful thing to have an employee, right, that wants to do more work and wants to do more honest work. And I feel like this situation here, unfortunate based on, I think, maybe multiple misunderstandings between the parties, but, I'm hoping that going forward, that the respondent can accommodate complainant's request for or desire to work more hours, right? In a loader capacity or some other capacity in a way that's mutually satisfactory to everyone. Just want to put that out there.
Thank you.
Any additional discussion?
Okay.
Anyone else can talk. All right, it's been moved and seconded to find no reasonable grounds to believe that discrimination occurred. If you're in agreement, you will vote yes. Commissioner David,
Yes.
Commissioner O'Brien.
Yes.
Commissioner Douglas,
Yes.
Commissioner Sanders.
Yes.
Findings are no reasonable grounds. Thank you both for participating, and you will receive a letter from the commission confirming the findings.
Thank you.
Thank you.
The penultimate case is E230406, Michael Emerson versus Lowe's. And the recommendation is for a finding of no reasonable grounds. Therefore, we will hear from complainant first.
And I will recuse myself from this matter. Well,
As I do. I got rid of all my other pins.
Get them back.
I hit replace instead of add. Sorry, guys.
The fact that that's the first technological hiccup.
I mean, I'm pretty proud. I didn't say I got myself that. You're just been going real smoothly.
It has.
Barbara, in your defense, you did say that you would mess up with the discussion a couple times.
That's right.
Skip that.
Is Amy doing anything?
Yeah, and no,
I'm sorry. Sorry.
Amy also is not texted me, which is good. Hopefully she's not watching.
Okay, I think we have everyone.
All right. Next up, we have E23-0406, Michael Emerson versus Lowe's. The recommendation is no reasonable grounds, so we'll hear from complainant first. Attorney Morris, you have 10 minutes. Would you like to reserve any of it?
Sure. I won't use the 10, but you could reserve 2.
Okay, you can go ahead.
Thank you. Still morning. Good morning, everyone. My name is Sally Morris. I represent Michael Emerson, who's also here by video. We are here to suggest that the investigator's report is recommending that there are no reasonable grounds to believe that discrimination has occurred should be rejected, and that there should be a finding that there are reasonable grounds to believe that discrimination has occurred. And I think here there's a substantive difference in the analysis of the case. The investigator's report really focuses on whether Lowe's violated the statute in failing to hire Mr. Emerson for the bench manager position that he was attempting to apply for in August. Whereas here, our position is that when Mr. Emerson was, when he had resigned from his position and was making an effort to rescind that resignation, all within no more than 7 days of each other, that's where Lowe's failed to accommodate and violated the statute. So to be fair, the investigator's report does address our position in a footnote. It's footnote 2 in the investigator's report. And you can see from what's in the investigator's report and in that footnote, the key here is notice. And as my supplemental submission to Mr. Emerson's response to the investigator's report indicates, we believe that this case is like the Criado versus IBM Corp case, which is a First Circuit opinion, where the First Circuit found that the failure of IBM to allow the employee to rescind or to come back to work, even though they sort of clocked that employee as a failure to return from leave, was in error because there was information being provided about the person's ongoing mental health issues. Here, Mr. Emerson, as the investigator notes, per se, is the statute applies to him. He has bipolar disorder. The events that gave rise to his resignation were all in the course of a manic episode brought on by his disease. He indicated, his submissions indicate that in June June 16th, when he had the performance meeting with his district manager and the area HR representative, he disclosed that he was suffering from his own emotional distress due to various circumstances in his personal life and his own serious health condition. After that time, he went on leave. So he was on leave from June 27th to July 3rd. The day he came back from leave, and our view is that the record shows that the day he came back from leave, he was continuing to sort of decompensate from a bipolar episode. He was immediately confronted and brought into a room and asked about some question about a safety meeting, at which time Mr. Emerson said, "I'm checking out." Now, if Lowe's had followed its ordinary procedures, when he came back on leave, he would have been put on inactive status. There would have been a follow-up with respect to a doctor's note, and there would have been an opportunity to fully engage in the interactive process. Instead, while he was undergoing a mental health crisis, he was put into a small room and confronted about things, to which his reaction was expected and brought about by his disability. He immediately tried to rescind that resignation, and the company didn't allow him to do that. We believe that, again, consistent with that case I cite, the First Circuit case, that is a failure to engage in the interactive process, a failure to accommodate, and discrimination.
Thank you. Questions for Attorney Morris? Commissioner O'Brien.
Thank you. Good morning. Are you, is Mr. Emerson refuting the claim that he did not go to the safety meeting? Did he go to the safety meeting? I guess it's just plain question.
Okay, so I think there's two responses to that. Number one, that's not really relevant to the fact whether Lowe's accommodated his disability or not. And I think the second thing is what he has said in his submissions is that he started the safety meeting, had his assistant run the safety meeting while he left the meeting and went and dealt with a customer service issue on the floor. When he was confronted, the day he returned from his leave, he wrote down all of the people who were involved in the safety meeting, including himself, though for a short period of time.
Thank you.
Thank you. Any further commission questions for Attorney Morris? Seeing none, you'll have 5 minutes and 10 seconds when we come back to you. Attorney Peterson, you also have 10 minutes. Would you like to reserve it?
I will. I don't want to break tradition, so I will reserve 2 minutes as well. But I also will not need anywhere close to that. Thank you. Good morning. Jeff Peterson with the Littler Mendelson firm on behalf of Lowe's. I appreciate the opportunity to respond. Lowe's obviously agrees in full with the investigator's report in this case. It is undisputed that Mr. Emerson resigned his employment, and at the time that he did so, no one at Lowe's was aware of his bipolar condition, that he was in the middle of a manic episode, or frankly that he was in the throes of any sort of health condition. He had returned to work. Lowe's therefore could not, the individuals, his managers, could not have discriminated against him on that basis. Ms. Morris argues, that Lowe's could have accommodated Mr. Emerson by allowing him to rescind his resignation, which he attempted to do, although she said immediately. It was actually a week after he resigned, when he submitted an email to his manager. There is no legal obligation for companies to allow employees who have resigned to rescind, even if there may be some connection to a disability at that time. And the case that Ms. Morris referred to is not to the contrary. I pulled that case. It actually is a termination case, so that first and foremost is different. It also had to do with an employee whose condition was well known to IBM being the employer in that case, prior to their termination. And so the argument, to the extent that the court held that IBM had to sort of reverse its termination decision after the fact, it was based in part on the fact that the court's finding that IBM had prior knowledge of the disability at the time that it made the termination decision. And that both of those aspects are not present in our case. I also wanted to address sort of the argument, Mr. Emerson's argument, Ms. Morris referred to it as well, that Lowe's should have done something more. And had it done something more, Mr. Emerson then would have disclosed more about his condition. There's no obligation for a company to require any sort of documentation. In fact, it's probably discouraged for employers to require medical examinations every time an employee returns to work after having been off on a leave for a week. But more to the point, nothing was stopping Mr. Emerson from disclosing any conditions he was having, any problems he was having, nor was there anything stopping him from requesting accommodations. Lowe's has a very robust accommodation process through its third party Sedgwick. As a store manager, Mr. Emerson either was or certainly should have been aware, because many Lowe's employees are accommodated through this process. So he certainly had the ability to have said, time out, I'm having this medical episode. I would like to request an accommodation. I would like to take time off. Lowe's would evaluate it, but that's not what happened. Instead, in the process of looking into, not even having made a determination about a potential performance issue, but just the investigation thereof, Mr. Emerson said, instead of submitting a statement that was requested, he said, I quit. And again, at that time, none of his managers were aware that he had bipolar disorder or was in the middle of a manic episode, or that frankly anything was wrong, since he had returned to work and without restriction. So just to kind of sum it up, the evidence is pretty clear that Mr. Emerson resigned. Lowe's accepted his resignation. Mr. Emerson, for whatever reason, regretted that decision, tried a week later to rescind it, but Lowe's was well within its rights to say that they had accepted his resignation and were moving forward. So that's all I have. I'm happy to answer any questions.
Any questions for Attorney Peterson? Seeing none, you will have 5 minutes and 20 seconds when we come back to you.
Thank you.
Attorney Morris, you have 5 minutes and 10 seconds.
Thank you. I guess the only thing I want to add is that Mr. Emerson, in his response to the investigator's report, did indicate that he specifically disclosed that he was having a mental health problem at that point. And so the question, I guess, is what constitutes adequate notice? And we believe that there is adequate notice here such that the interactive process should have occurred. Thank you.
Question?
Sure.
At what point, Attorney Morris? You say, I think you're saying that complainant disclosed afterwards that previously he was having a mental health crisis, but the issue is whether or not he disclosed that at the time. Did he?
Yes. I mean, in his response to the investigator's report, he indicates that the June 16th, 2023 meeting with his district manager and area HR, that he disclosed he was, these circumstances were affecting his mental health. So then he went on leave after that, the 27th through July 3rd.
What circumstances were affecting his mental health?
Well, specifically what he says is during a meeting on June 16, 2023, that's a I'm not quoting that, that's a summary, just to be clear, about the e-car, which was a performance issue. During that meeting with my district manager and area HR, I disclosed that I was experiencing emotional distress due to my wife's cancer diagnosis and the stress from relocating. I explicitly stated this was affecting my mental health.
That's not disclosing the fact that he has a disability that requires an interactive process, is it?
Well, he said, he goes on to say area HR gave me the Lowe's Care mental health hotline number. So obviously they were on notice that there was a mental health issue going on. Certainly, you know, certainly I would submit that, you know, the employee doesn't have to use magic words to say, I need a reasonable accommodation. They just have to disclose certain information.
That's all.
Okay.
Any additional questions? Seeing none. Attorney Peterson, you have 5 minutes and 20 seconds.
Okay, thank you. I will take virtually none of it. Again, Lowe's believes that the investigator's report, in particular, footnote 2, because it appears that Mr. Emerson has chosen not to pursue any further claims relating to a subsequent application for positions after his resignation, is supported by substantial evidence. So request that the investigation be upheld. Thank you.
Thank you. Any questions from the commission for respondents council? Seeing none, we have heard from the parties. We'll now hear from investigator Karen McCarter.
No, so nothing I've heard today changes the recommendation. And I'm happy to answer any questions.
Questions for Carrie? Seeing none, thanks. All right.
I'll make a motion.
Well, okay. Jump right in.
I move that the commission find that there are no reasonable grounds to believe that Lowe's unlawfully discriminated against complainant on the basis of disability, and the complaint should be dismissed.
Second.
Thank you. Any discussion? Sure, when I remember, there isn't any. Seeing none, it's been moved and seconded to find no reasonable grounds to believe discrimination occurred. If you're in agreement, you will vote yes. Commissioner David?
Yes.
Commissioner O'Brien?
Yes.
Commissioner Douglas?
Yes.
Thank you. The findings are no reasonable grounds. We appreciate your participation. You'll receive a letter from the commission confirming the results of the hearing.
Thank you.
And the last case is a housing case H25-0036, A, B, and C, Jolene Couture versus Rose Robinson et al. The recommendation is for that we find that there's no reasonable grounds on all 3 allegations, and therefore we will hear first from complainant.
Ms. Couture, is that you on the phone?
Oh, yes. Good morning. Well, good afternoon now.
You're up. You have 10 minutes. Would you like to reserve any of your time?
Yes, 2 minutes.
All the cool kids are doing it. So you can go ahead.
I'm following. Yes, I would like you to change your decision ruling on the basis that Rose has not participated in any of this complaint I put in, have submitted. And the other issue is with the charge, the management was trying to find me guilty of the assault charge, which indeed I sent to the investigator copies of the court's ruling. So I was therefore not found guilty of that, and that I would like that to be considered. Also, the countless conversations, emails, talks, messages sent to Rose Robinson in reference to that smoking and allowing them to smoke right in front of myself and witnesses, knowing I just had cancer and kidney disease. Same with Sue, doing her smoking in the area where I live, following me, blowing smoke at me. Those are the things that I am asking for reconsideration, and the management, the eviction should, I was slandered, the eviction should have not taken place before the court decision, as I stated in my conference back in April, that she wasn't the judge and jury, and so the judge did decide I indeed was not guilty, admitted by the management, Sharon, well, that I have done this before, which is not a fact, and that this issue with Sue and I was both, but I was the one that got the eviction before I was even found not really guilty.
Ms. Couture?
So that's what I have to say right now, yes?
Thank you. The decision in your criminal trial was not in the record. So we're not going to talk about
well,
that.
I had sent that to the, I have a copy that I had sent that to the investigator, and I have recently sent that again.
Yes.
I sent that again a month or so ago.
Yes, after the record in your case had closed, but that's fine.
I sent it before it closed. I went to the hearing with the judge on April 29th, and that same day I had the answer from the judge, and I sent that. I have verification that I sent that to the initial investigator. And that wasn't considered.
Okay.
So
the investigator is
therefore,
saying
the eviction took place. That shouldn't have happened because I was not guilty of the said accusation.
Thank you. You will have 7 minutes left when we come back to you. Are there any questions for Ms. Couture? Commissioner Douglas.
Yes. Good afternoon. So I'm reading the investigator's report, and it looks like, and I'm just going to lay out some facts, and I want you to tell me where you disagree. Okay, so it looks like there was a smoking policy, right, implemented by the respondent. And it looks like it was enforced, and that you made complaints that they responded. Reminding people about the policy, posting signs around the complex about the policy, issuing warnings and lease violations to people who violated the policy. And so what I'm wondering is, what else did you want the respondent to do here? I mean, you understand, hold on a second. I think we all understand that, all they can do is try to enforce the policy, right? They can't make people not violate it, right? Which is when people violate it, then they have to enforce it. So I'm just wondering, what else did you want them to do?
Well, like I had just indicated, the management, Rose Robinson, was the one that allowed the cigarette smoking with her present, and told me when I confronted her with it immediately after that took place with a witness, she said it's okay because I was there. And they did not enforce it. I have videos which I submitted to the investigator of Mike, I can't remember his last name. He's the maintenance supervisor, walking right towards my kitchen. I, to this day, have that video of him with a cigarette in his mouth. I got a lease violation for complaining about N2 people that came to do ground services, smoking cigarettes, driving on the lawnmowers right in front of my apartment, right by your face. They do it. I got a lease violation for that. So no, that is not accurate. They did not enforce that. When it was complained, if it had been addressed like they had stated, people wouldn't have kept doing it. Even their own maintenance person did it. And that's the maintenance supervisor. And I do have that video still. So that is what I wanted, yes. And like I said, the management did it herself, allowed it.
Thank you.
You're
Any
welcome.
additional questions for Ms. Couture? Seeing none, you will have 7 minutes when we come back to you. We will now hear from respondents.
Good afternoon. I'm Danelle Maloney. I represent respondent 2 and Ken Valley Housing Group. My apologies, my name's not on there and I didn't want to risk getting kicked off and not being able to get back on to fix that. So I'm going to reserve 2 minutes of my time.
And what is your name?
Danelle Maloney. It's Maloney, Milone. I've been involved. My name should be somewhere on the documentation. Thank you.
Thank you.
And my colleague Ben Pollock's also available too. But in this case, I'm not going to take up much time. My client, 2 and Ken Valley Housing Group, just requests that you accept Investigator Brinley's recommendations of no reasonable ground. We believe she came to the correct conclusion. With regard to Ms. Kocher's statements this afternoon, she stated that Ms. Robinson had not participated in anything with regard to this complaint. That's correct as an individual, but I would like to note that the property manager, Coastal Property Management, has been involved in some of the testimony here and has provided evidence specifically as to the actions of the property management company and my client, 2 and Ken Valley Housing Group, as to the responding actions that did take place after Ms. Kocher's complaints. Of all the things that Ms. Kocher has stated here with regard to any complaints that she made, those were addressed. If she sent in videos with, as it pertains to the maintenance individual, he was spoken to. You've seen the record of additional letters posted to the entire property, additional signage that went up. The restrictions for smoking were extended to include areas of the housing that are above and beyond the HUD housing restrictions. So my client was making a reasonable effort to accommodate Ms. Kocher here. Anything else would have required setting up cameras or hiring another individual to monitor, and perfect compliance is not the standard. It would have been an undue burden for my client. With regard to the assault, my client's got an obligation to the rest of the tenants and residents in the housing group. They are required to ensure that they've got a safe property. The police report indicated that Ms. Kocher was the aggressor in this matter, and that was corroborated by our individual investigation and discussions with the police officers who were involved in that. There was no evidence of the spitting. And so when the eviction began back in September, the landlord moved forward with the evidence that they had. The eviction was completed in January of 2025. So with regard to the overall complaint, we believe that the investigator's decision was correct and accurate, and we do request that the commission adopt those findings in this matter.
Thank you. Any questions for Attorney Maloney? Commissioner Douglas.
Yes, so just to briefly revisit what I talked about with complainant. And you did sort of address that. I just want to make sure that we're all clear on the same page. So she says that, people, like this maintenance man is coming around and smoking, and the other people are sort of flouting the policy right in everybody's face, and that nothing was done about that.
Mm-hmm.
Your position, as I understand it, is that, like, for example, these videos that you referred to, these were known to you folks, right? And when you received a video, other evidence of people flouting the policy, you took action, right?
Correct.
Is it in the record as to what action you took with respect to this maintenance person?
I'm not sure if it's specifically in the record. I can tell you with this particular maintenance individual, he was spoken to by the property management company. And as it relates specifically to the content of the videos, it's very important to note that the content's not clear. And complaints made, it was not clear whether individuals were actually in violation of the policy, because the videos were taken, that particular video was taken, or one of them was taken while an individual was walking on his way to the smoking bench. He had his cigarette out, not while he was smoking in an area outside of the smoking bench, we'll call it. There's other evidence as it relates to Ms. Couture's actions, particularly she would sit on the bench and prevent other individuals from coming to the bench where they would be able to act on their right to smoke. And so with each of these complaints, the reactions by property management, the reactions by my client, they continued to be more directed. And so it's a dual process of trying to establish whether a violation was actually taking place or whether and what to do about it. So when it was interactions with lone individuals, particularly the maintenance man, they had a discussion with him and advised you shouldn't do that again, and he didn't. So it was not being flaunted as Ms. Couture states in her testimony.
Thank you.
Any additional questions for Attorney Maloney? Seeing none, you will have 7 minutes and 20 seconds when we come back to you.
Thank you.
Ms. Couture, you have 7 minutes.
I have a video right now on my telephone of that maintenance man we're talking about walking towards my apartment with a cigarette in his mouth. And he did it frequently. I have witnesses that have done that. And I did not sit at that table. That is not true. I used to sit under that tree by the laundromat community building every single day with my sister that resides there. That is not accurate. And as for the assault, that never took place. We have a judge. I have provided you copies that indeed dismissed the case, did not find me guilty of such a thing. So officers are human beings. They make mistakes. That is not accurate. For now, that's enough.
Okay. Any questions for Ms. Couture? Being none, thank you. Attorney Maloney, if you have anything to add.
I just have one brief thing. I just want to bring up a provision of the lease, which is a part of the record here. And it states that if a landlord determines that a tenant has engaged in criminal activity, regardless of whether the tenant has been arrested or convicted for such activity, they may move forward with a termination. So I just think it's important to note that here in this instance, and that was one of the reasons the landlord moved forward to evict at the time that it did.
Can I speak on that?
No, I'm sorry, your time is up. Any questions for Attorney Maloney? Seeing none, thank you. We've heard from the parties. We'll now hear from Investigator Alex Brindley.
Again, it is officially the afternoon. Good afternoon. I don't think I have anything to add. There was mention of the judge's decision in regards to the assault. It was provided after the close of evidence deadline. I determined that regardless of what was written in the decision, it didn't really impact the finding in my report, so I did not include it in the report. Open to any questions.
Questions for Alex? Seeing none, thanks. We've heard from the parties. We have the investigator, and we're now looking for a motion. There are 3 proposed findings because there are 3 responses.
I move to accept the investigator's recommendations reflected in the report as written. 1, there are no reasonable grounds to believe that Rose Robinson discriminated against Jolene Couture on the basis of disability. 2, there are no reasonable grounds to believe that Susan Hilche discriminated against Jolene Couture on the basis of disability. And 3, there are no reasonable grounds to believe that 2 and Ken Valley Housing Group LP discriminated against Jolene Couture on the basis of disability. And finally, the complaint should be dismissed in accordance with 5 MRS section 4612 subsection 2.
Second.
Thank you. Been moved and seconded to find no reasonable grounds. If you are in agreement, you will vote yes. I was so close. I know. Is there any discussion? There isn't, so I'm gonna call for the vote. Again, if you vote yes, you are in agreement with the finding of no reasonable grounds with regard to all three respondents. Commissioner David,
Yes.
Commissioner O'Brien,
Yes.
Commissioner Sanders,
Yes.
Commissioner Douglas.
We're gonna have to recall the vote. You called her before me.
I was just making sure
I can't
people
have
were
that.
paying
I
attention.
can't have you call them. Good vote, the voices.
Thank you. The findings are no reasonable grounds. We appreciate your participation. And you will receive a letter confirming the findings of the hearing.
Thank you.
You want a motion to go into executive?
Only if you want to.
Sound like a
Sure,
motion.
sure. Pursuant to 1 MRSA 4056C, I move we go into an executive session to consult with our attorney pending uh, contemplated litigation and the legal rights and duties of the commission.
Moved and seconded. That would go into executive session. Is there any discussion before you move in? I've had some discussion.
I think that Barbara's done a fine job. Make sure that
All of you have, I think all of you.
Michael, Jane,
Hold your applause if you make sure executive session works correctly.
This is where it gets complicated.
Okay.
I'm sure.
But for Jane,
I just want to see if you could do it.
We're gonna do it.
here we go.
Okay, so everybody,
Wait, no, we can't go yet.
okay.
We're still in discussion. I need a vote. All right, if you vote yes, you are coming with us into executive session. Commissioner David,
Yes.
Commissioner O'Brien.
Yes.
Commissioner Douglas.
Yes.
Commissioner Sanders. Yes. Okay.
Audio.
We have a lot.
Now we have audio.
That was the remix version.
Excellent.
Now how did that go?
80s.
We need a motion to approve the settlement agreement with the Greater Brunswick Housing Corporation I don't seem to have the court number, but it's in Superior Court right now. I will fill in the court number. The underlying commission case is H23-0374-A, Maine Human Rights Commission for the use of Patricia Gallant versus Brunswick Housing Corporation. Do I have a motion to approve the settlements?
So moved.
Second.
Thank you. It's been moved and seconded to approve the settlement agreement. If you vote yes, you are in agreement. That came out backwards. Commissioner David.
Yes.
Commissioner O'Brien.
Yes.
Commissioner Douglas.
Yes.
Commissioner Sanders.
Yes.
Great. That does it for our meeting.
You guys did a great job. I just ended?
End it.
Yeah.
Oh, can't.
Bye.